Just kindly one writ appeal labor matter, my lord. Both the parties have already settled the matter. My lord. Have to be referred to the Adalat, my lord. Tomorrow for admission, my lord, they will come. I will get. It's in the office. Still, it's in office objection, my lord. Is it still in office objection? Already settled the matter.
How many objections are there
Yesterday it's filed yesterday, my lord.
to the objection? We'll have it day after tomorrow.
Plus, since 12th is the national Lok Adalat, my lord, we will report this settlement.
List it. Let's see. Yes.
But maybe 3 contempt petitions, fresh matters, my lord. Contempt petitions, fresh contempt, my lord. May I seek a request?
Objections cleared?
Objections.
Take it.
Grateful, my lord.
And permission. Writ appeal 900 is listed on 22/7. A similar matter on the same subject matter has been filed before the Kotal number 7. This matter may be listed with that matter. My lord.
Which matter?
Challenge writ petition number 19344.
Listed with before.
With writ appeal 900 of
No, where is this listed?
22nd of July, my lord.
Before this court?
For this court.
So we'll take it up on 22nd.
This matter may be listed along with it.
No, no. Where is the matter? Is the matter listed before another court?
Yes, my lord.
So make a request there.
I made a
So
request
make a
there.
request there.
They asked me to file the memo here, my lord.
We will not. Unless you have to make it there, that court need to pass an order, if at all, then we will look at it.
My lords,
Commercial appeal. My application under section 8 has been rejected, despite there being a clear arbitration clause. 37 lords, I filed an appeal. Matter is listed on Friday before the trial. I have filed an appeal before this court. Lordships may have
When is the matter before the trial
Lords,
court?
it is tomorrow's. I have not
Take
requested.
an adjournment, we'll give you a date, but objections cleared.
Yes, all objections.
Just take it after a week or 10 days.
Please.
my lords, it's a fresh matter. It's a civil contempt against the order of this honorable court dated.
Take it, ma'am, that.
My lords, it was on the last date. It was listed that the matter be taken up after 2 weeks. My lords, the 2 weeks are over. So we are filing a fresh
Oh,
memo.
is it a pending matter?
No, it's a fresh matter.
It's a fresh matter. Which, how do you say that it will list after 2 weeks?
My lords, the honorable court itself had directed that it
When
be
did you
listed after
mention
2
that?
weeks. My lords, on June 25th.
Ma'am, just check up. Were you given any date?
No, my lords.
No.
It was
could
simply
not- It
mentioned.
cannot be possible. We give you a date.
My lords, it was mentioned that
We'll
list after
just
2
check up.
weeks. Please, my lord.
Fresh contempt matter will
Objections cleared?
clear. My
Take it,
Serial
ma'am.
number 30.
Pardon?
Serial number 37, my lord. I am a petitioner. Kindly press 1 week.
We'll come back. Any other mentioning? Yes, ma'am.
My lord, fresh matter. It's been filed yesterday. The objections have been cleared.
What is the urgency?
The revenue records are likely to be mutated, my lord, and I'm facing certain threats of dispossession.
Just take it, ma'am. Just have it 1 week after.
Lord,
Who has disposed of which combination has disposed of? You have to mention it before the registrar judicial. This was regarding that order. Acha, no, you have to mention it before the registrar judicial, then it will come there. Is it a pending matter? You want a hearing there? File an early hearing. File an early hearing.
My lord, in respect of in-service doctors who had got admitted in the month of February, interim orders were passed recently and a contempt petition has now been filed. But they have to start studying their course. So contempt has been moved.
You are for whom?
For the petitioners. In this case, for the petitioners, my
For
lord.
the petitioners.
For the
so you
petitioners
want a
who are
list-
in-service doctors for
Well,
listing
list-
of the contempt, my lord.
Listing of the contempt.
Listing of the contempt.
Objections removed.
My
Objections
lord,
removed.
my lord, we'll get it removed today, whatever they
So
are.
you then mention it. Remove it, mention it. Okay? Huh. What is the urgency? No urgency.
I have complied with the office objection, my lord.
It's not listed.
Not approved.
Just take it, ma'am, after 2 or 3
My
days. Yeah. You have removed the objections? Take it, ma'am, after 2
My
years.
lord, contempt petition, my lord. Press matter, my lord.
Can you see the roster? Two thousand,
Sorry, my lord.
2016. What is that? You are right. What do you want? Just take it that, man. Just 1 minute. Don't go. What is this?
2016.
It's not us. You have to mention before another code, roster code. That's all? Yes.
They had registered in the airport.
Subsequently, their lordships transfer. Matter is sent up, matter was given 13th June.
Which court has given 13 June?
That their lordships matter. But it has to be heard before, by constituting the division bench. So that matter is before your lordship, or towards administration side.
But have you mentioned it before the registrar?
Yes, but we mentioned this,
You give a memo to her.
we given and the conveyed us is that matter is before your lordship.
What is the number?
That is the writ appeal number 2476 of 2015 and other connected writ appeals. It is the state's appeal. We are the respondents.
Huh.
So that it's very urgency.
No, what is there? The bench has to be constituted.
Yes, madam. Special bench has to be constituted.
Have you given the memo?
Yes, madam. Lovely, we are.
Very well, we'll see it.
Please,
What is this?
same memo, madam.
You give it there, not here. Okay. What is this matter? What is this? Is writ appeal? Is it a pending writ appeal or a fresh? Objections removed. Just take it, man.
Lords, can leave, Lords. Seal number 54.
We'll come back. That's all, no mentioning. Yes.
Lords, seal number 54 and 55, my lords, connected matter with seal number 5, all arising out of the same common order. My lords, I appear for the respondent number 1 in 54.
54, yes.
My lords, on the last date,
Hearing here?
Please, my lord, I appear for the,
my lords, on the last date, my learned friend had undertook
In this
to
matter, my lord,
serve copies to us. And based on that, my lords, no order was given to that effect. However, no copies have been served. And hence, we are, my lords,
So there are in all 3 matters?
3 matters, my
serial
lords.
number 5 is also connected to that. My lord,
Please.
may make one submission. Since, my lord, this is the appeal of the Union of India, Director General of Civil Aviation. Let it be on record, let it be on board, my lord, because the ASG is leading us in this matter. Lord, we'll make some submissions, my lord.
My lords,
Be on board. Today, my lord. Today, my lord.
Just wait. Let
my
the
lords,
matter-
there is just one difficulty, my lords. I am led by Captain Arvind Sharma, who has a difficulty today. And we don't have the petition papers, my lords.
Okay. Now tell us
Any
one thing.
date may be fixed, my lords.
What is the urgency for you?
Lord, the contempt is filed.
When did you file contempt?
My lords, contempt was filed prior to the writ appeal. It is listed along with the writ
Okay,
appeal.
very
So there
good.
is no.
So we will adjourn the contempt also. But
Please,
you will
my lords.
not press for any, in any case, they
My
can't
lords,
press
it's-
Mr.
I cannot
Bhushan.
press. It's connected, my
Is
lords.
the ASG coming?
Is there, my lord?
Ask him to come at 5, at serial number 5.
Your Honor,
Please, my lord. Please.
Just wait.
Great. Great.
serial number 55 itself connected. I'm filing my memo of retirement. He's
And I
taken
have
up the
already
wakalat.
filed my wakalat,
Where
my
is
lords. My
the-
name is reflected.
Just 1 minute. Just 1 minute. And 5.
55.
55 is also connected?
Yes.
Just wait. Then let the matters be called. We'll take it up along with 5.
Same as 65, my lord. Up with the first respondent. I am led by Senior Counsel Colin Gonsalves, my lord. He is not available today. Lordship may kindly take it up.
55. Who appears for the others?
The management, my lord.
For whom?
First respondent, my lord.
But where is the counsel for the petitioner? Have you mentioned to him?
Not informed, my lord.
Should inform him, no?
Please.
We'll just let the matter be taken up.
Please, my lord.
I am here for petitioner 37 serial number, my lord.
Yes.
Kindly press time, my lord, 1 week. ಅದು additional documents ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ ಕೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್
37. What do you want, ma'am?
Kindly press time, my lord.
You are for whom?
Petitioner.
You have informed the other side. There is one more, Mr. Prasanna. You have informed Mr. Prasanna Setti. Who is the contesting party here, madam? The state? Just say that at the request of counsel for the petitioner. Adjourn to
39.
May I make a serial number 41, minutes. Serial number 41, and I am representing the respondent.
Just 1 minute, just 1 minute, ma'am. Just ask her to just show us the file. Is there any interim order? Let the counsel be. Man, just wait. Let the matter be called. Okay?
My lord,
Yes.
can I make a submission, my lord?
Yes.
My lord, serial number 14, my lord. I'm for the complainant. Press for a week's time, my lord.
Nothing further survives in the contempt petition as such.
Hmm.
My lord, we'll rely upon the senior advocate to make submissions, my lord. Since he's not available today.
Nothing further survives in the contempt.
Why?
petition. Because it was with regard to direction of allotment of a seat, it's been complied. Cost was imposed, the cost was deleted before the Honorable Supreme Court. So all the
What do you
directions.
say?
Lord,
You appear for whom?
complainant, my lord.
We'll take it up. Let's see.
Lordships kindly, serial number 41 minutes. I am for the appellant in the first appeal. The respondent in 41.3. May kindly grant me some time, let's say. And I have informed the other side, minutes.
Just say at the request of Mr. Vivekanand for 41.2,
Yes.
appearing in WS 72724, comma, to which Mr. P. N. Rajeshwara has no objection, re-notify on. Both 41.1 and 40.2. Just say that Mr. Vivekanand appearing for Karnataka State Industrial Infrastructure and Development Corporation Limited in the contempt petition as well as in writ appeal.
Writ appeal. Apply.
Notify.
99.
Call the list.
Serial number 1.
Lords, I represent appellant, Lords. I apologize for not filing a translated copy of annexure F2P, my lords. Lords, however, my lord, I am relying upon the document 1, my lord, at page number.
Just show us that.
But based on the order passed in WP, my lord, the respond number 1 to 5 are trying to.
But what is the ground for challenge?
Lords, based on the order passed in WP, my lord.
Huh?
It was not ready, my lord. The translated copy was not ready, my lord. That's
So you want to file it?
No, my lords. Before that, my lord, Stay has to be granted in this case. Why? Because, my lord, the respondent number 1 to 5, my lords, based on the order passed in WP, my lord, they are trying to they get the khata in their name with respect to properties are concerned, my lords. The properties are around 16 acres, 20 guntas.
So, but the khata, who will do change the khata? Who will give the change the
They
khata?
have already filed a representation to Tahsildar, my lord. The representation
So was
is also.
Tehsildar a party?
Yes, my lord.
So Tehsildar had filed. No, who are you? You are the panchayat.
Yes, my lord. I am R7. I mean, I am Panchayat Development Officer, my lord.
What do you say? No, what is your ground?
My lord, these lands are not actually, it is a government Gomala land, my lords. And these were respond number 1 to 5 are private parties, my lords. And they have sought for Sagoli chips, my lord. And
But what about the subject land was granted to them?
Lord, presently these lands are granted for needy people, my lord. Ashraya Yojana, for the purpose of Ashraya Yojana, my lords. At document 1, my lords, document number 1. It's an order passed by Honorable Deputy Commissioner, my lord.
But the grant was in 79.
Those are fake documents, my lords.
A direction is given to us to verify the genuineness and pass necessary orders. Lordship may kindly see.
How are you agree? If they verify it, you will represent to them.
Kindly turn to page number 191, my lords. Same land has been allotted for the purpose of formation of the land for Ashraya Yojana, my lords.
Right. So that's the scheme for you to allot.
Yes, my lord.
And your case is also if they are forged or fabricated documents. That's right.
Yes, my lords.
You will represent to them. Yeah. After verifying the entire records and take a decision.
Yes, my lords. But they are R1 to R5 presently, my lord. They are pressurizing the Tahsildar to get the khata, my lord.
You mean to say that Tehsildar, he will agree with them? He will not apply his mind? What is this? He is required to follow this.
True, my lord.
Required to follow this.
Yes, my lords.
So if he is pressurizing, he will do it.
But if they do the khata in favor of R1 to R5, my lord, then, my lords, the very purpose of preserving the land.
Suppose it is found that the grant was properly granted and they are genuine documents. Then what follows? Then what follows?
Let him verify in accordance with.
He will do it.
That is the direction. That is the direction.
He will do it.
Till then, my lords,
Why should we till then? Then he will not be able to do this exercise. If we put a stay, he will not be able to do this exercise. Ultimately, who has to satisfy himself? The Tehsildar?
Yes, my lords.
You clear the objections. We have nothing. We don't see any merit in this.
No, till then, my lords, notice may be served to the respondents, my lord.
Tell us how this order is wrong or erroneous. Tell us.
No, my lords, if the land is granted in favor of R1 to R5, my lords, then
how do you presume it would be granted? Suppose the Tehsildar, after going through this exercise, say the documents of grant are fabricated. He will stop at that.
You go before the Tahsildar and say
Ah,
that it's
say it.
fabricated. Show that there.
Well, with that direction, my lord, if this.
We can't give direction. Why we should give direction? We have already given direction. The single judge has given the direction that it should be verified. You see the last paragraph. The respond number 4 to issue khata in favor of the petitioners after verifying the entire records. After verifying the entire.
See, even though there is an observation, there is no impediment.
Yes,
but still the verification need to be done.
Yes, my lord.
After verification, he will give it. What do you want?
But with the same direction, my lord, once again, it may be directed for Tahsildar to look out the documents.
How many times we have to reiterate our order?
Presently, my lords, off the record, my lords, they are pressurizing by the local politicians.
Pressurizing, then you come after he pressurizes and under pressure he succumbs. Then you can challenge that order.
Because, my lords, the total extent of the land in
The
survey number.
verification is not correct. That you can say.
Obviously, you will say so. The verification is without any this thing, and this is our. And will he have a hearing before the?
Lord, there is a representation from the writ petitioners, my lord. If they have any objection, let them file it. We will consider that as well, my lord, while verifying.
So whatever you have said, so give a representation to Tehsildar. Whatever you have said in the appeal, give a
In
representation.
the form of an objection, my lord, because writ petitioners have filed the representation. Let them, if they have any issues, let them do the.
With these observations, it may be disposed.
We will only record your submission
Yes, my lord.
that you will withdraw this appeal, okay?
Yes, my lord.
To enable this petitioner herein file a detailed representation to the Tehsildar.
Yes, my lord.
And we will consider it along with the writ petitioner's representation. Both.
We require them to be here. Just say this, this challenge in this appeal, writ appeal is to an order passed by the learned single judge in writ petition number 13 dated 4th June 2025. In writ petition 13899 of 24. Whereby the learned single judge has allowed has disposed of the writ petition filed by the respondents 1 to 5 by stating in paragraph 5(3) as under. Full stop. It is the case of just say that after some submission, learned counsel for the appellant states he shall withdraw the writ appeal to enable the petition appellant herein file a detailed representation to the Tehsildar.
Yes, ma'am.
Full stop. Noting the said submission, the petition appeal is dismissed as withdrawn.
Yes, ma'am.
Next.
Serial number 2, Shri Manjuna.
I appear for the petitioners in this case. Apologies for, there are 4 objections. I was told the objections were all complied, but based on that, I had moved the memo, my lord.
3 weeks to remove the objections.
A week may be granted.
We'll give you 3 weeks.
Date maybe.
Next date, give the date.
11/8. Serial number 3.
Filing my ADS along with all the documents that I proposed to file.
The order copy is released, my lord, so to trial court.
They have released it.
Yes, my lord.
You are filing the objections.
Yes, my lord.
With the
Order copy.
yesterday, my lord, in the other writ petition which my learned friend had filed, the learned single judge has passed an order dismissing their petition, where not all these issues have been again argued and considered. Maybe your lordships can have it tomorrow that the order come. Your lordship may take a look at that order because possibly there may be something in that order.
Give it to them, give it, file it.
I've given
in
a
the
copy to
registry.
them. I'll file it in the registry.
File it in the registry.
Yes.
Possibly if you can. File it in the registry.
Yes.
Give a copy to them.
I've given a copy.
Let's have that, Mr. Raghavan, that order of the learned single judge also.
I'll see it, my lord. My learned friend told me, and my learned friend also told me
We'll
about
have
it.
it. No, you want to file any response to this?
I'll see what they have said. I will see what they have said.
Just say that Mr. Chinnappa appearing for the respondent states that he shall file the objections in the registry during the course of the day.
Yes.
The appellant shall be at liberty to file a rejoinder to the same. Within how much time?
Lord, we'll file it tomorrow or day. Tomorrow it will be filed. We received a copy, so.
File within 1 day. Just re-notify on.
Oh. No, I'm so sorry. It's not a statement of objections in the appeal, no. It's the statement of objections filed in the lower court. It's only a paper book.
Oh, that's all you are filing. You are not filing this.
Nothing.
Okay.
We'll adopt the same objection because I think that was not placed before.
That we have filed already. You want the objections that they filed in the trial court to our petition under section 9 is already on
it
record.
part of the record otherwise?
Yes, yes. It's part of the record.
Then just cut it. Just say that we have been, Mr. Chinnappa states that a writ petition between the same parties
Between same parties.
has been dismissed by the learned single judge and he intends to place on record the order passed thereof.
Yes.
Let the same be filed by tomorrow.
As soon as released. Not it released, my lord. But it was passed yesterday afternoon.
We'll have it then Tuesday.
Right.
Tuesday.
My lord, let's not be precipitated with police coming in, my lord. That's the only request I have.
I have
You
videos
let it-
today
let it-
of
otherwise-
the students, my lord, attending classes. Absolutely no difficulty.
Very good.
There'll only be danger
I
if
am
my
not-
learned friend comes there and causes
My lord,
disturbance.
See, it's a status quo order.
Only then it will be
Right.
disturbance.
Whatever is status quo which may inure to both the parties.
Yes, yes.
That's right. But the only thing is, any third party interference is there?
No third party interference. The interference is by them.
No, no,
If
no,
they
no, no.
come
That-
in,
that- that
there'll
is
be
a-
disturbance.
Manoj, that is a
The
disturbing-
whole objective
that
of a
is a
status quo order is to argue
disputed
this.
Mr. Agban, we will not say anything. Status quo order, which may endure, you will
Yes,
also.
yes,
We say nothing more than that.
yes, that's it.
So we say nothing because status
Well,
quo
Your
is
Lordship
there
may
by the
state-
court
Your Lordship
below.
may say status quo because that order was there till the order was passed by the commercial court, vacating the order. It was there. So please continue.
That
is all
status
I'm
quo order
saying.
was actually
That-
passed because I filed a memo in court at that point in time, pointing out lot certain illegalities committed by them. There was that both sides made a status quo. Today say both sides
That
made
is so,
a
Manoj, I
status
want to
quo.
make a
Is
few
my humble
submissions.
submission is very
I want to
dangerous.
show a few facts. I want to
It's a
show.
matter of few days, Mr. Agban.
No, in the meantime, let not the police interfere. But the whole difficulty is now is all becoming a mess at the place.
At whose instance police are coming?
Well, we don't know either instance. Let them not come.
Yes, Lord.
I am saying,
Let your
let
lordship
not
may
the
say,
police-
police
let
shall
not
not come into the school. Very well. Lordship may say that. Lord. I don't want the police to come anywhere near the school because my worry is they are going to go and bring the police.
But
We'll
if
do
my
one
learned
thing
friend-
only. We say nothing, even that order would not. They have to enter the premises. They have to enter the premises. Even police makes an attempt to come inside.
Yes.
Well, otherwise they can't do it unless and until someone has actually forced them. If they enter, who are those police people who have entered? That record you can maintain.
Yes, I can maintain
We will
that.
see it.
Yes, Lord.
See.
No, my lord, so from our side, I can tell
Agban,
you
it's
no
like
police
this.
will come.
They would not really enter, unless somebody really calls them. If someone is entering, so you also say that they should not enter, he also said they should not enter. But the fact remains, suppose they enter, who are those people who have entered in police uniform, the names, everything recorded?
And there is one other, my lord, that's one, yes, my lord, that we will do. Now, the other point, my lord, is that till 3 days ago, when the interim order was vacated by the learned commercial court, my lord, there is a status quo order. My lord,
I appreciate that.
That is
We
all
will-
that I'm
we
saying.
will- We will look into, that's the challenge here. That's the challenge here.
Yes.
You're getting that? We'll have it on Tuesday, we'll hear it.
That the whole difficulty, my lord, is we do not want the respondents to change the position as it exists today.
What are you expecting?
But they have done it now with respect to one of the schools, my lord, they have come and forcibly taken over and we are not able to even enter. That's the difficulty that we
What
have.
is the effect? What are the changes which is sought to be?
But nothing, we are not able. We are not able to even run the school now because of the one school in Bangalore. This is the problem.
Yes.
My lord, we have been now, my lord. The position is since 2012, even according to
We'll have it on Friday. Get your order.
Friday, my lord. Yes.
Right.
Friday.
7-7.
Yes, Friday.
Yeah, great.
Get that order of the learner single.
Yes, I'll get that. As a matter of fact, the portals, everything has been changed in March itself. The portals of CBSE has been changed. They challenged those before the learned single judge. First petition, not they withdrew. When the learned single judge was about to pass an order, they withdrew the petition.
See, my lord,
The second
I
petition,
don't know.
no,
My
but
learned friend is saying that.
I was there, sir. That's what I'm saying. So you weren't there.
I am not disputing it.
I'm
I'm
saying
saying
what
what
happened in
a learned
court.
single judge said. Has said. I mean, I'm not disputing what my lord.
I'm only pointing out that in the school that my learned friend is pointing out, the Bangalore school, they filed a petition to say, please change the Saras portal of the CBSE back to their names. The court was about to dismiss it. They withdrew the petition. Now they filed it again for Mysore. Since March, it has been changed from the name of the principal in the earlier school to now. That has been
my
dismissed by the
instructions are
court.
the circumstances under which the writ petition was withdrawn was different. They said we are going to agitate it before the commercial court. That is the reason why it was withdrawn, not because we gave up our right. In fact, not the admitted position, and I'm saying so on the basis of records. Admitted position is that even pre-COVID, we were running the school, even according to them. And now, my lord, in order to formalize that understanding, we entered into that MOA. Now, there was a dispute with respect to the amounts that was required to be paid under that MOA. That has been terminated. But it does not mean that the understanding relating to running of the school is gone. And my lord, even at the worst, my lord, I am in a position of a licensee.
But tell us one thing, Mr. Radha, other than MOA, what is the basis for this relationship?
The students, my lord, we are the ones who are getting the students into the school. We are the ones
We
who
are right. What we want to say is, what your submission is, The MOA is what we have understood is this. MOA really is not with regard to the relationship, something different. That's your submission.
My lord, it is so, my lord, partially, and it was also in respect of other things. But the MOA does not create the relationship. MOA is only to formalize the relationship. That relationship has been going on since pre-COVID days. And, my lord,
Something unwritten on that.
yes, and I have got, they have admitted it in the pleadings that we have been doing it. And therefore, my lord, I am saying, what is the worst position that I am in? I would be a licensee. I mean, even assuming, my lord, that the license is terminated, under section 60 of the Easement Act, I am entitled to reasonable time to vacate. Now, what is the, no, my lord, what is the reasonable time?
This is not property
my lord, this is
dispute.
not a case
When
of
did this
just
become a
removing
property dispute?
My lord, 1 minute, sir, 1 minute. It is not a case where I just remove tables and chairs and go. My lord, there are children. Therefore, my lord, academic here we cannot disturb now. Let the children be disturbed. Let things continue till April of 2026, so that there is no difficulty. There is a school management committee, which is what is mandated by the statute. The school management committee is in
Friday. Thank you.
Great. I said it only as a response.
No.
Nothing else.
We have understood this. To be very fair, we had now more clarity about what you are also saying, what he is also saying.
Great.
Thank you.
Actually, with what my learned friend is saying, Lord, the MOA has no value. Then why come under arbitration clause? They should do something else.
That we see.
Wherever it's convenient, you want a forum, but
thank you. Next.
Number 4, yes, Nagaraj.
I appear for the petitioner, my lord. I have already complied the office objection again. They have raised. I will do it, my lord. In the course of the notice may be ordered, my lord. It is a ex-servicemen's. The land is granted. They cannot identify. Order of the learned single judge is at page 63, my lord. Page 63, my kindly look into my.
Respondent number?
Respondent number 1 only. The only respondent Tahsildar is to comply the orders.
Complainant number 3. This is Pushpa.
Page 63, my lord.
You should first carry out these objections.
My lord, I carried out it twice. Again, they have raised it. I will do it now itself today.
No, just see the cause title about petitioner number 3, the complainant number 3.
Complainant number 3, my lord, Pushpa, wife. KB Pushpa, my lord. My lord,
that's the objection which has been put. And what is wrong with that objection?
But the objection, my lord, Pushpa was wife of K. Bhimaya. It is there in
you should say, just say objections be removed within 1 week. Just have it after 2 weeks.
30th 7.
Lord, this is
Yes,
our
Mr.
appeal.
Kama.
Appeal number 5.
But there are
I
three
appeal
appeals.
for the
The
caveat
other
or
two are
respondent.
listed at 54 and 55. Lord, the writ petitioner has also filed a contempt. Lord, this is regarding renewal of a airworthiness certificate. The petitioner, who is a practicing advocate, has been flying a small microlight aircraft. And we have certain civil aviation requirements, which requires not to lease it out, to have insurance, not to use automotive fuel. But the writ petitioner has been using automotive fuel to fly the aircraft, has been allowing video recording equipment to be taken on the flight. So we had raised certain shortfalls, like an office objection that the registry raises. When he applied for the renewal, we had raised certain shortfalls. Now, learned single judge has set aside the shortfall. And my lord, the writ petitioner goes to and threatens our officers that I will draw you to contempt. We will do this. We will do that. Lord, the matter will have to be heard. Lord, kindly grant me some protection. Lord, the learned single judge could not have quashed the shortfalls that we have raised. For example, one of the requirement is there shall be insurance. Admittedly, the writ petitioner does not have insurance.
My lords, may I make one submission?
Number 2, my lord, he is allowing
People have posted video taken from the aircraft on YouTube. Our MHA requirements does not allow any video recording equipment because the IAF Air Force Station is just 4 kilometers away. There are a lot of other sensitive installations. There are a whole lot of compliances which he has not done, and learned single judge not by a very cryptic order has quashed all the shortfalls that we have raised.
May I make one submission, Lords? My Lords, first of all, learned senior friend is making submissions on the matter where I am a caveator. Copies have not been served to me. The contempt also is listed along with it. There is no grievance insofar as they're concerned. I am not allowed to fly. I will satisfy your lordships as to all the requirements and the regulations that we are in compliance with, and that is why the learned single judge has passed the order.
I am ready to argue.
My Lords, may kindly fix a short date and let them serve copies. My Lords, on the last date, it was on my learned friend's oral instructions that the copies would be served, and hence no order was passed to that effect. I'm only
just give him a copy.
No,
please.
we have, my Lord, we have served my learned.
What about who is appearing in the other appeals?
My Lord, there are 3 petitions. 2 pertain to use of automotive fuel. 2 of them. One of them pertains to the shortfalls. There are 3 appeals arising from the 3 writ petition.
All in one common order, my Lords.
Who appears in the other 55? You appear for 55?
My Lords, in 55, I appear, my Lords, and my friend, Mr. Dhruv M. Patwari, he has filed his memo for retirement. I have filed my wakalat. My name is anyway shown, my Lord. His name may be deleted. 55.
Are you, so we take it, are you appearing for all the respondents?
Please, my Lords. Respondent number 1, please.
But I have, on 30th January, I have served, I have got acknowledgement issued by my learned friend's office.
That is the same counsel who's filing.
Who is respondent number 2 in item number 5? And who is appearing for him?
Lords, respond number 1 and 2 in item number 5. I am the caveator, Lords.
You are the caveator.
Please.
And in the rest, just give us 54, 55 appeals. You have the appeal, Mr. Kamath, to give it to him for in 54, 55?
54, 55 copy. In all 3, my Lord, we have given, but my Lord.
How have you given? Is it through an email? What?
No, physical. My Lord. Issue notice. Issue notice.
No notice.
Notice was issued by your lordships, and we have given the process fee along with the copy. I have got the acknowledgement.
No, you have filed the process fee along with this.
Yes. My colleague has got the acknowledgement.
Just give it another copy, Mr. Kamath.
But my Lord, there is no difficulty in giving one more copy to my learned friend. There is no difficulty. But my Lord, this was listed on 23rd of June.
Lord,
and my Lord, without intimation to us, my learned friend
no,
took time in the morning.
Learned DSGI was there. He made a submission that the copies would be served. On that basis, my Lords had not passed an order.
Consistently, the respondents are taking time. On the other hand, they threaten the officers.
In fact, I am not able to fly, my Lords. There is no.
Please, 1 minute.
But he has the copy of the impugned order. I do not know why he.
He should have a copy of the appeal, Mr. Kamath. He should know what are the grounds. So we take it, all the appeals have been given? 5, 54 and 55.
Lordship may record his submission because I do not want a similar submission on the next date.
Lord's writ appeal 164 is now being served.
What is this number? This is 55 or what? 181. So you have got all the 3 appeals?
Lord's only writ appeal 164, my Lords.
164 is item 5.
Please, my Lords, 50, that is 54, my Lords.
See, give a copy to him.
Lord, we had given it through the registry.
Just show it, forget registry,
Okay,
Mr.
ಇನ್ನೊಂದ್
Kamath.
ಸ್ವಲ್ಪ ಅಲ್ಲ, ವಿನಯ್.
Then if
You-
we
you fresh
need to look into the registry will serve, that will never happen. Just give him.
ಇದೆಯಾ ರೆಡಿ ಇದೆಯಾ ಈಗ? Not my colleague Vinay will hand over during the course of the day. Lordship may record. Lord Vinay will hand over during the course of the day. He'll make photocopies and hand over.
Just say that a copy of the appeal being WA 164 of 2025 has been given to the learned counsel appearing for
R1.
respondent number 1 and 2 or 1,
1 month.
2 also.
P4 R1 Malads must Agni Aerosports.
No, once we are saying of 164 has been handled, that's 54.
Please Malads. 54 is where I appear for respondent number 1 and 2.
The respondent is Mr. Palinavelu.
Please. Palinavelu.
And 2 also see.
Please.
So 1 and 2 you appear.
Yes, Malads.
Okay, this is in item 54. Man. What about this Mr. B. Bhaskar? He's an aircraft engineer. Who appears for them?
Malads, I have no instruction on that.
Just see the memo.
Malads, as per they have been served, no one represented on the previous occasion, Malads. In fact.
What is this, Mr. Kamath? Who appears for 3 and 4?
Not in which matter, Malord?
164, 54,
164.
54.
164. Lord, he is a non-contesting party. We have arrayed him as a respondent because the writ petitioner had made him a party. Notice has been taken out on him.
Would you like to serve him? What?
The office note says that he is served.
Office
In the
notes.
causeless, the office note says that he is.
54 says we have not issued notice.
He has been served in contempt, Mr. Kamath.
Yes, Lord, sound big. Lord, we do not know where he is whereabouts. We will take out fresh notice, Lord.
Let fresh notice be issued to 3 and 4 also? 4 also.
4 also. That's a private party.
So this is 4 also in item 54. Now come to 5. 5
I appear for the caveator respondent number 1 and 2.
for caveator. This is 192. So you appear for 1 and 2.
Please, Malads.
Now what about 3 and 4? Air traffic controller would be your person. He's your officer. He comes under Director General of Civil Aviation.
Air traffic controller, not that would be the
Government
state government,
flying
of the flying training school. The flying training school is a state government employee.
3 and 4 are of the state government.
State government. Lordship may direct the AGA to take notice.
Yes, just show us that to him.
Government flying school.
Even this government flying training school will
Yes,
be under government.
state.
So you accept that? So and so accept for respondents 3 and notice for respondent 3 and 4. Now we have 187-55. You have got the copy of the appeal?
Malads, 192 I have not got any
Let a
copy.
copy of the appeal paper.
187 is served.
That's one you have. served.
192.
192
Number
you have
5.
to serve them.
Till
Item
number
5.
5 I'll do.
Be served on the council for respondent number 1 and 2. Rather 1, 2, 3, 4.
My Lord, in 187, R2 and R3,
Yes.
the AGA can take notice.
Just be during the, when will you serve? Course of the day?
Course of the day.
Course of the day. Then in the 55, 187, you appear for 1.
Please, Malads, 1.
1 so and so accept notice. Let a copy of the appeal paper book be given to the council appearing for 1, 2 and 3. 2 and 3 the AGA is appearing. So
Lord,
But
187 we have already given.
Malads, in seal number 55, Mr. Dhruv M. Patwari's name may be deleted.
1 minute. 187 copy has been given. It should say only 3 and 4. Yes.
Malads, Dhruv M. Patwari's name may
Which
be
number?
deleted. That is for R1. He was the caveator R1.
Yes.
Which one?
In seal number 55.
So you will appear?
Please, Malads. My name is already shown He is filing his memo for retirement.
You are Mr. Arnav?
Arnav A. Bagalwadi.
Just say that Mr. Arnav so-and-so says that he has filed Kalat
Yesterday,
on
ma'am.
behalf of respondent number 1. And as such, the name of Mr. Dur Patwani, who was the caveator, on behalf of respondent number 1's name be deleted. It's ordered accordingly. Okay, re-notify on contempt and all these appeals together.
No, would your lordship take it up?
Just say that Mr. Kamath states that the appeals being item number 5, 54 and 55 arises from the same impugned order.
Yes.
Be tagged together for a common decision. It's ordered accordingly. Okay.
Would it be possible to
When
take?
do you
it?
want? Tell us.
There's some
I'm just-
urgency later this week, not Friday or Monday, my lord.
We'll have it Tuesday. We'll have it.
Tuesday.
Obliged. Obliged.
What is the date?
Ishtu Nanda.
Bill number 6, Vijay Kumar.
Lord, I appear for the respondent. I made an application for recalling of the earlier order. What happened was a public interest petition came to be filed, alleging encroachment on a Rajkal way. There we filed objection saying that there is no encroachment on our part. However, the court disposed of the matter, directing the deputy commissioner to examine and pass an order. And the court also said if there is an adverse order passed, you can question it in a separate proceeding. Then after the disposal of the writ petition, an application for extension of time was filed by the authorities. While considering that application, the Tahsildar also conducted an inspection, conducted survey, found that my property is outside there is no encroachment. But notwithstanding that, the deputy commissioner passed an order saying that there is encroachment. While that order of the deputy commissioner was passed on to the court directly said that the encroachment will have to be ordered to be removed. Whereas I have sanction plan, occupancy certificate, everything. I have independently challenged the deputy commissioner's order. But the observation in this is, without giving me an opportunity to challenge, virtually it says that straight away encroachment has to be removed. Noble Lord, your lordship may kindly take my application for recalling. I have produced at page 9 of the application for recalling. In the first order passed by the court, at page 12, para 2, the court disposed of the matter.
Yes.
There, my lord, para 2, we therefore issue the following direction. Petition be treated as a representation to the Deputy Commissioner, Bangalore Urban, about the encroachments made on subject land, which incidentally is a government land, public property. The Deputy Commissioner, Bangalore Urban, shall cause an inquiry to be made into the grievance, shall be obliged to take an action against encroacher for removal of encroachments on public property with utmost dispatch. Then, my lord, next page, after referring to it, last para at page 14, para 6. If any adverse order is passed by the Deputy Commissioner, affected persons will be given a week's time before taking action on the basis. Then, my lord, the authorities made an application for extension of time. And the Tahsildar also conducted a report, a survey. Survey says there is no encroachment. And notwithstanding that, the Deputy Commissioner passes an order against us saying that there is an encroachment. It was handed over in the court. Court straight away passed an order to remove the encroachment without giving us an opportunity.
Where, which court?
This honorable court, at page, in the application itself I produced, page 71. Which was not even given to us. Straight away it was given to the court. Page 71. Pursuant to an order of this dated 7/8/2020, the report is submitted to this court through learned additional government advocate, so and so. It is presented by Shri Balachandra, Special DC, So and so. Thereafter, my lord, then next page, para 2, the Tahsildar is directed, last 8 lines in that page. Tahsildar is directed to remove the encroachment. I have the sanction plan.
But did you challenge
This
the
I
order?
have challenged it independently, but the court said that there is this order is stayed. But the point here is, my lord, this order says that straight away to take action. It comes in the way of my pursuing the proceedings parallelly of challenging this order, because the court does not say that originally it said that affected parties can file challenge it, but here it says Tahsildar Bangalore South Taluk to take all necessary steps pursuant to the order of special DC dated 2010 so as to remove the said encroachment, take possession. In fact, I have produced the survey report saying that there is no encroachment.
You appear for the petitioner. You have filed the reply to this application.
No, my lord.
Now you have initiated the separate proceedings.
I have filed a writ petition where it is stayed, my lord. This order of deputy commissioner is stayed. But the court also was of the view, this observation, it will come in the way of your decision. That is why, my lord, I have.
One submission.
Yes.
But kindly see page 71. May I read this order, my lord, entire order, because I read the entire order. Pursuant to the order, page 71. May I read?
Yes.
Page 71 of
Who is you are which respondent?
Lord, I am respondent number 11.
Okay. Now let's read that. You said 71.
Please.
Yes.
So this order passed after hearing both the parties. Pursuant to the order dated 7/8/23, a report is submitted to this court, though the learned additional government advocate representing the state. It is presented by Sri S.N. Balachandra, Special Deputy Commissioner to Bangalore, South Subdivision, Bangalore. Learned additional advocate, government advocate invited our attention to certain statements in the report indicating that the Special Deputy 2, pursuant to the order of this our court, undertook the exercise of going the record and hearing the parties and ultimately arrived at the conclusion reflected at the part of the order of the same source. By invoking the provisions section 62 of this 13 Karnataka Land Revenue Act 1964, I hereby direct the respondent owner of the site number 1450 so and so to vacate and hand over the possession land to the government within a week from the date of this order. Failing with the Tahsildar Bangalore South Taluk is hereby directed to take all the necessary steps to remove the encroachment over the 1 acre 22 guntas in survey number 10 Patnagiri village Kengeri Hobli, Bangalore South Taluk, and to take a position of the land in favor of the government and report the same to the Deputy Commissioner, Bangalore Urban District, Bangalore. Accordingly, the above matter has been disposed of. So, para 2. The learned additional government advocate further submits that the state has had deposited the amount of cost of rupees 2 lakhs in the office of this court. Now, considering this part, emphasized by her, it is clearly indicated that though the Special Deputy Commissioner to Bangalore Subdivision, Bangalore, directs the subordinate officer, of Bangalore South Taluk, to take necessary steps, there is no time frame fixed for the purpose. As such, the apprehension cannot be ruled out. That is, the direction will be only a paper direction without any actual implementation, and this situation would only help the wrong those or the mischief players. As such, we deem appropriate to direct the Tahsildar Bangalore South Taluk to take all necessary steps pursuant to the order of the Special Deputy Commissioner 2, dated 25/10/2023, as to remove the said encroachment and take possession of the said land in favor of the government and report the same to the Registrar General of this court by separate report and expeditiously as possible, not later than 12 weeks. We further make it clear that in case the Tahsildar Bangalore South Taluk needs assistance from the Law and Order Maintenance Agency, Police Authority, or any other administrative authority, he may immediately initiate such request of the concerned competent authority, and on receipt of the communication, the concerned authority shall at once provide a necessary assistance, cooperation to him, so as that the order of this court dated 5/10/22, in turn, the order of the Special Commissioner 2 dated 25/10/23 are complied within a letter spirit. The Tahsildar Bangalore South Taluk to submit the report to the Registrar General of this court along with the copy of the order of the Subdivision General immediately for a purchase. Automatically, the copy of the orders to furnish the learned and so and so. After that, Milad, it is a government land. Milad is 11th respondent is a builder. The government land without any permission from the government.
You want to file a reply to this?
No, Milad.
You don't require.
Please,
now, tell us one thing.
Give me 1 week time.
Yeah. The earlier
Matter has come
order,
nearly 6-7 times.
Well, now what happened, my lord?
The application has already come 6 or 7 times. They have not bothered
all
to.
right, if they want to file, we can, otherwise he doesn't want to file.
Well, what happened now? Recent developments in the Deputy Commissioner office. Now the 11th respondent is a very powerful and is a very powerful person. He set up some other land belongs to the government, and he prepared a report to in respect of some other land.
Survey report is there.
Now they wanted to grab this because survey has been conducted by the 3 times by the survey through the Tahsildar and Deputy Commissioner. When the cost was imposed by the 2 lakhs by this court to the Deputy Commissioner, the Deputy Commissioner appointed a Tahsildar and Resident Commissioner along with surveyor, conducted 3 times. And they conducted the 3 times. The 11th respondent was encroached this property. They had given a clear direction and the report to the Deputy Commissioner. On the basis of that, the Deputy Commissioner submitted a report to this Honorable Court. After hearing both the sides, this order was passed by this Honorable Court. Now it is not necessary to recall this order because now already they filed, when they issued a notice by the Tahsildar and the Deputy Commissioner, they filed a writ petition before the Honorable Court, they granted interim order. By virtue of that, they are escaping from the clutches of law.
Since he wants
This is
to
the
argue,
situation.
Lord, I'll submit a few facts.
Otherwise you did not take this order in appeal.
Which order, my lord? This is passed in writ petition by the division bench.
No, that's 25/10/23.
No, they are not challenged.
No, this order, the order itself is passed after the disposal. Original order says that I have the, while disposing of the petition.
You're right, you're right. Original orders, since you are not a person before the court, they grant you liberty. If you are any adverse order is
Correct.
passed, you can seek your remedy.
Correct.
Possibly
That order is part of this entire proceedings. Court cannot say no, that I have no right to challenge it at all. That is why, my lord, in the statement of objection, I pointed out that I have occupancy certificate, I have a sanction plan, and nearly 45, nearly 50 apartments are constructed, about 45 flats, my lord, different people are residing there. And the plan also says at page 35, survey says that there is no encroachment.
Great respect on submission. Final order ಇದೆ ನಿಮ್ಮ ಹತ್ರ? Final order. Sir, final order. Final order ಕೊಡಿ. ಇಲ್ಲ final order ಇಲ್ಲ. ಇಲ್ಲ final.
Page number 9.
ಇಷ್ಟು.
So your submission is, in the writ petition, this would come against you.
Yes, yes, because my right to challenge it, my lord, cannot be taken away. And otherwise, this court will have to decide whether this is correct or not. For that also, I am ready because I have produced in the statement of all documents. I have produced all documents which says that land is converted, Khata is there.
Is he a party there? The
No,
petition?
he is a public interest writ petition.
That in the writ petition, intentionally they are not made a party. Then I filed an application for impleading in the learned single judge. That application is pending.
Who is pending?
It is
pending.
My application is pending before the learned single judge.
My limited, my
Right.
limit.
But tell us one thing, the earlier order says if any order adverse to is passed, they are at liberty to challenge. But now the subsequent order conclusively proves or conclusively gives a finding against them that this is an encroached land. That's right. Submission is, 1, it is at variance with the first order. 2, then there is no remedy left. That has attained finality. That's right. So what according to them is, this observation should not come in the writ petition. Otherwise the writ petition says, what is there? This conclusion against you, we can't do anything.
Well, after submitting the report, this Honorable Court passed a final order final order. I will produce that copy.
Pardon?
And that after submitting all the reports with the Tahsildar and Deputy Commissioner.
There is further order.
There is no further
After
order.
this.
No further order.
That I think,
That's the reason you want to file a reply. Please,
Please, I'll file
put
a
it
reply.
on record, whatever you want to say, not orally.
please,
We
I'll
want
file a
on
reply.
record.
Please give me 1 week time.
Which is this IA? IA 1023. This is an application filed by the respondent number 11
In the
for recall of order dated 25/10/23 in the Writ petition. Mr. B.N. Nagaraj.
He's a petitioner. I mean, Vijay Kumar advocate. On record.
Will a counsel appearing for the petitioner states that he shall file a reply to this application. Full stop. The same be filed within
1 week.
within 1 week. Rejoinder be filed within 1 week thereafter. Re-notify on.
One week.
Yes, ma'am. Twenty-fifth of
That
October.
order is there, part of our application.
No, that's the 25/10.
It's part of that. That is,
That's right. But no, but is there any other order of 25? That's the first order. That's the second order, of which he is seeking the recall. That is there.
One request. That, in some of the flats are vacant in the premises. Now the respondent number 11 tried to sell the property. If you sell the property.
this has become a private interest petition. This is the problem, Lord. It's public
I will
interest.
tell you, Mr. Vijay Kumar, you are not concerned. Are you concerned with that?
That is a public litigation.
That's the only say. So his submission is, Mr. He said ultimately it's a public interest. The public would suffer if ultimately it
That
is.
is only the.
Building is constructed and nearly
that's all.
45 families are residing.
Innocent
Survey is
people-
done.
No,
Innocent
occupancy
people cannot
certificate is
suffer
given.
after
There is a
purchasing the
question.
That's
property.
his
That is my
concern.
humble request, Mr. That's all.
Ultimately,
concern.
my lord, we are bound by whatever your lordship should say, ultimately decide. in
They
the
are
matter.
selling the crores of rupees of the property. If a poor
Crores
person,
of
a
rupees
person
I have
purchase
spent.
the property, suppose if the
Crores
court.
of rupees I have spent, I have constructed the building in accordance with law, sanction plan is there, occupancy certificate is there, land is converted, everything I have produced before the court.
Mr. That in any case it should be. But his only concern is the public must not suffer. Ultimately found
Correct,
that.
that's the lordship will decide
Okay,
whether public
thank you.
will suffer or not.
We direct the respondent not to still dispose of the application.
Why?
Well, if they sell the property.
But then
Tell us one thing.
Let him argue.
We are only on recall application. That writ petition is pending there.
Please print
You
it.
have sought your impleadment.
Yeah, ma'am.
Will you seek an order there or here? Today, this petition has been disposed of. This is only a recall application. If you want anything, possibly that's the place.
Please, my lord.
Getting?
Proceedings.
Thank you.
Thank you.
1/8.
Yes.
Serial number 7.
APF for respondent number 3 minutes.
Filed a memo for retirement, Your Lordship. The advocate on record has been appointed as the additional advocate general, who is disabled from appearing. We've also given the NOC vakalat. And on 28/1, the Honorable Court has to intimate the petitioner by way of RTD and keep that also on record, Your Lordship. That has also been filed, Your Lordship, on 11th.
Ma'am, you are seeking a retirement on whose behalf?
On behalf of advocate for the petitioner, Your Lordship.
Who represent the petitioner today?
No, Your Lordship. I'm here to find.
You have to ensure there is some, representation for petitioner.
We've
Then-
intimated them by way of RTD notices as well, Your Lordship. Petitioner 3 and 4 have received the notices, but there's been no reply from the others.
Yes, sure. How many are there? How many petitioners are?
9 petitioners, Your Lordship.
So they have not responded to your communications.
No, Your Lordship.
Madam, mic use, madam, mic use.
Where is your application for retirement?
Lordship, it's filed
Have
on.
you said so that they are not responding to your communications?
Yes, Your Lordship.
Sure.
On 11/3, we've on record, Your Lordship. The postal receipts as well.
See, you have to serve, otherwise 1, 2, 6, 7, 8 also.
They've been served, Your Lordship, but it has been returned as not
How
available.
can that be served and returned? Maybe the address is not complete.
We'll serve it again, Your Lordship.
Do it, do an attempt. We'll not, you see, we want a representation now.
Yes.
Unless you say so, they have been served, they are not responding to your communication, then we will. proceed.
Petitioner number 3 and 4 have been served, Your
We
Lordship.
can't do it piecemeal, na ma'am. It has to be in composite manner.
Yes, Your Lordship. We'll
At
serve
the
it.
request of counsel for the petitioner adjourned to. You take your steps.
Yes, Your Lordship.
28-8.
Obliged, Lordship.
Lord, the office
For the
objection is,
respondent number 7 to 10 for the contesting. My lord, I want some time.
File, ma'am.
I pray some time in this to file a statement of objection. We are the contesting 7 to 10.
Just 1 minute.
the office objection is, my lord, respond number 2. Counsel Mr. V. Raghunath, my lord,
Has a notice been issued?
has filed an wakalat.
You appear for whom?
And for 7 to 10, my lord. Respondent number 7 to 10. We are the
Now let's
contesting.
see, state of Karnataka, who appears for the state? Ma'am, you appear for 1, 2, 3.
Sorry, for respondent number 3, I appears. For
3
respondent
you
number
would appear. Okay, give your appearance, please.
Please.
4, 5, 6.
4, 5, 6. 7 to onwards,
Myself.
7 to
7 to 10, my lord.
7 to 10. Okay, just take the 1 to 1, 2, 4, 5, 6 madams and 3 learner councils and 7 to 10. Just give your appearance.
Right.
Now, what do you want?
No, my lord, this is the regarding the relief is to quash the judgment passed by the district judge, civil court as back as in 1969. My lord, so in that respect, my lord, I want to file a detailed statement of objection. Some of the records we have to get from the PWD of the respective area. And the whole contesting point is,
Counter affidavits be filed 4 weeks, rejoined 3 weeks.
yes,
Adjourned to.
My lord, the earliest
Question, my
your
lord.
lordship may give a date, my lord, there.
You're giving a date.
Lordship, one submission. Respondent number 2, my name is shown. Registry be directed to delete, my lord, since government is, advocate is representing.
Just say that Mr. V. Raghunath.
Yes, please.
Just say that the name of Mr. V. Raghunath for respondent number 2 be deleted. As respondent number 2 is represented by learned AGA.
Respondent number 2.
Okay.
15-9.
I make one submission, my lord. I have not received a complete set of.
Take it from your friend. Just give a complete
Please,
copy.
Number 9.
Complaint, my lord. It's a contempt petition. They held the enquiry after my retirement. Order has been passed by this honorable court to give the promotion on par with the other persons. They have held the enquiry after my retirement. I am entitled only for the salary. Their objection is.
Let's see that. When did you retire?
First accused has been retired about 4 years back.
No.
Second accused about 2 years back, my lord.
Okay. So before 24.
Before 24. The only thing is they have to pay the salary on the date of my promotion pursuant to the order of this honorable court, my lord.
No, but in any case, there is a liberty granted to them to hold inquiry.
They were the party.
So
They are the appointing authority. They denied my promotion. I made a representation stating that my contemporary colleague has been promoted on the same ground. I may permitted to place me in the same cadre. That has been considered by this court. After retirement, they filed an objection stating that the enquiry has been.
Easy promotion when inquiry is being done. On account of reversion.
The direction was, my lord, to hold an inquiry. Accordingly, my lord, an inquiry has been held and endorsement has been issued.
What is the endorsement?
Saying, my lord, that he doesn't.
He does not?
Does not get the promotions.
But tell us one thing, if you see paragraph 6.
My lord.
What is this impugned order of 22/9/16?
That is the earlier endorsement, my lord. That was
Stating
challenged.
what? Stating what?
Saying, my lord, that he is not entitled for the promotion.
That's right. Now, that has been set aside.
Yeah, obliged.
That means he is entitled to promotion.
My lord, the inquiry is to be held because inquiry was not held.
Very right, very right. So the liberty was granted to hold inquiry.
Obliged.
Very well. So 3, 4, 5 will follow.
Yes, ma'am.
That's it. Now 6. Now this 6th direction, if promotions conferred on the petitioners are upheld, post inquiry, the respondent corporation is bound to pay the difference of salary. Now, what is the inquiry conclusion of the inquiry?
My lord, what happened, my lord? According to Uma Devi's case, my lord, he is not entitled for the post held by. He is saying that I'm parity with the other employees, my lord. I should be given promotion. That doesn't come.
No, this inquiry has resulted in any penalty?
No, my.
Well, then what did you do? What happened to the inquiry?
My lord, now that he is retired, my lord, he said that he is not entitled for the promotion.
Oh.
According to the, my lord,
Would not be. No, if promotions conferred on the post inquiry. Now, in the inquiry, he has been absolved of the charges?
No charges. No charge. There is no charges at all.
No, the inquiry, does it lead to any penalty imposed on him?
No.
Then promotion will
my lord,
follow.
what happened, my lord? Page number 5, I just read 2 seconds, my lord. Page number 5 in my objection which I have filed, my lord.
No, but tell us one thing, from which date he is entitled to promotion otherwise? Where is that 2016 endorsement? Where is that?
No, that is not produced here.
See, it's like this. You gave them promotion. You
Withdrawal.
You did not give them promotion, or you withdrew the promotion.
We withdrew it.
Withdrew the promotion, but the inquiry was not held.
Yes.
The learned judge has set aside the withdrawal of the inquiry and gave you liberty to hold the inquiry. And if you see 6, if promotions conferred on the petitioners are upheld post inquiry, the respondent are bound to pay. Now it is your own case that in the inquiry the charges have not been proved against them.
Yes.
Are we right?
My lord, there what they have done, the conclusion what they have come, my lord. May I just, it's in Kannada, my lord. ಸರ್ಕಾರದ ಪವಿತ್ರ ಕೇಸ್ ಮುಂಬರ್ತಿ ಪ್ರಕರಣ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಇದ್ದುದರಿಂದ ಈ ಪ್ರಕರಣ ಸರ್ಕಾರದ ಅಂತಿಮ ಆದೇಶ ಹೊರಡಿಸುವವರೆಗೂ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಮುಂಬರ್ತಿ ನೀಡಲು ಸಾಧ್ಯವಾಗದೇ ಇದ್ದುದರಿಂದ ಸರ್ಕಾರ ಅಂತಿಮ ಆದೇಶ ಹೊರಡಿಸುವವರೆಗೂ ಮುಂಬರ್ತಿ ನಿಗಮ ಸಿಬ್ಬಂದಿಗಳಿಗೆ
ಸ್ವಾತಂತ್ರ್ಯ ಪ್ರಭಾವದಲ್ಲಿ ಪ್ರಭವಿಸಿ ನಿಗಮದಲ್ಲಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳಿಗೆ ನಿಗಮದ ಅಧಿಕೃತ ಜ್ಞಾಪಕಪತ್ರ ಸೋರಿಸೋ ಸ್ವಾತಂತ್ರ್ಯ ಪ್ರಭಾವದ ಹುದ್ದೆಯನ್ನು ಪ್ರಸಕ್ತ ಅವಧಿಯಲ್ಲಿ ವೇತನ ಶ್ರೇಣಿಯ ಕನಿಷ್ಠ ವೇತನ ಮೂಲ ವೇತನ 7.5 ರಷ್ಟು ನೀಡಿ ತಮಗೆ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ತಮಗೆ ಸದರಿ ಸೌಲಭ್ಯಗಳನ್ನು ಸಹ ಒದಗಿಸಲಾಗಿದೆ. That was also given to him.
Inquiry was regarding what?
My lord.
Inquiry which is contemplated in this order.
My lord.
Is regarding what?
My lord, as to why the withdrawal was made. My lord.
It is not in respect of any discrepancy.
What is the inquiry? Again,
I'll produce the inquiry report.
You file your affidavit.
I'll do that.
Let reply affidavit be filed within 4
One
weeks.
submission, Milan. After retirement, even if they give me the promotion, I'm not entitled to occupy that post. Because I have a inquiry was conducted only after post retirement. I'm entitled only
That
for the
is the
difference of
direction.
salary.
What is the inquiry?
They have to say it. They never.
See that.
Let them reply affidavit 4 weeks. Rejoinder 2 weeks.
The direction was to conduct the inquiry. My lord. That has not been challenged. My lord.
Why
Why should I?
What is the inquiry?
I'll produce the record.
Date may be fixed. Milan. Date may be fixed.
8/9,
Just tell him the date. ma'am.
8/9, sir. Serial number 10, 14%.
My lord.
For the second respondent, my lord, RP.
We have it somewhere. You appear for whom, ma'am?
I appear for the resolution question R2. The section of Green's name and Green's computer.
We'll have it some other day, Mr. Kriplani.
As you, my lordship.
Just re-notify.
Can it be after 20th of August, in the week of the 20th of August?
We will give you a date. So when do you want? After 20th August?
20th August, in the week of the 20th August,
Yes, week of
21st,
20th
22nd.
28/8,
28?
8.
Next.
Thank you, my lord.
Serial number 11,
It's in 11, my lord.
For the complainant. My lords, may I submit?
Because some landlords issue with the state association. Yeah, what was written in the laws by somebody else, like, that is all that's what public laws is suffered. It was an ex parte order, laws written at case number 29.
My lords, I don't mean to interject my senior friend, but that's a very simplistic view of the matter. My lords, it's a suit for defamation. It is first of all not ex parte. They were present, they have filed their written statement, they failed to lead evidence, they failed to cross-examine my witness. My lords, it resulted in a decree and judgment in my favor.
My lords may kindly take page 40 of Annexure A. The suit, my lords, has been decreed in the presence of both advocates. There is a cost, my lords, that we have recovered through an execution. That is right. But, my lords, what is pending is a simple apology. Now, my learned friend says there is an RFA pending. I have filed, my lords, a memo before this honorable court producing the status of the RFA. This RFA was filed last year, my lords. It has come up twice. This honorable court refused to grant stay because they said you have not taken a defense meaningfully before the learned trial judge. My lords, now what I'm only seeking is I want them to tender an apology. This will come to an end, my lords. It is
But
not
that's in the RFA.
the RFA, please, he is only asking for that portion of the decree now in the RFA, I believe, because execution of the amount is already over. My lords, I'm only saying if my learned friend's client were to tender an apology, all these proceedings will come to a conclusion.
Why should I be tendering an apology? Why should execution? The question arises, why should I tender an apology for what mistake I have not done? No, we see.
My lords, this is an inquiry on merits. This honorable's jurisdiction in a contempt proceeding, there is a direction, there is a deliberate disobedience.
But
as
tell
on
us
today.
one thing.
Please, my lords.
Now, the monetary part of the decree has been executed.
Yes, yes.
Then what remains?
The apology, and he has to take down the posts against me.
Is
That is
the
important.
apology part of this?
Yes, my lords.
Very well. Now, will you now, why two parallel proceeding? Have you initiated execution, still pending?
They have not contested the execution either. My lords, I would be satisfied if the remedy is granted by either of the courts. These are, my lords, parallelly maintainable. That we have no
For
quarrel.
that, we may have some issue on that.
My lords, the Honorable Supreme Court very
And in a
respectfully
different
says,
you're right, in a different circumstances.
I agree. My lords, it's only a question like this. This is not the first time that the same person has been accused of defamation, suffered multiple decrees from the Honorable Civil Court in multiple matters, not just in my matter. My lords, why I am pressing in this instance is because, my lord, someone takes advantage of a trial, appears but does not contest, knows of the execution but does not come forward. We had to take, my lords, the court Amina's assistance to get that 1 lakh out. It's, my lords, at the end of the day, it is a simple question of tendering an apology. Why, my learned friend asked? Because there is a decree to that effect. It's not because I am saying so. There's a decree to that effect after a fully fledged trial.
You want to give an apology, yes or no?
I have not done anything much. I respect you. There's something which was written already in the press.
No.
But that plea has not been accepted now, or even you will argue before the RFA court.
RFA court. We get an opportunity to reply this matter back. There were several minutes allegations of corruption.
No.
Oh.
We will not go into all this.
not go into
We are a different. No, we will put it to her. How is a contempt maintainable?
My lords, my respectful submission is that both an execution and a contempt proceeding on the same decree are maintainable.
Show us one judgment.
I can, my lords. Please pass it over and I can produce judgments.
And mind it,
Please.
there is no statement before any court. Which statement has been taken on record by the court and violated. It's purely a dispute in a suit resulting in a judgment decree.
Please.
Unless a statement made before the court violated, possibly you are right.
My lords, in my reading, if I may submit, the fact remains like this, my lords. The issue between the contempt, in the contempt petition, my lords, the discretion obviously lies with this honorable court, my lords, to entertain it or not. But it is a question solely between the contemner and the court. My duty as the person who holds a decree which is not obeyed is to bring it to the notice of this honorable
Then every
court.
execution will come here in contempt.
My lords, I had
Getting-
to take this recourse because after the execution, my lords, they remained disobedient.
You have a remedy there.
My lords, I have initiated that remedy. Again, my lords, this is a decree that is specifically to be performed. Under the specific relief act, my lords, a decree which cannot be specifically performed cannot be forced upon the person, my lords, on
There is
the
a
other side.
consequence. There is a
Civil
consequence.
prison is the only consequence, my lords.
You have a remedy there.
My lords, instead of that, if my learned friend were to kindly advise his client, an apology will end the matter.
I have interested in my counsel. He has not appeared at all. I have suffered.
You're right.
That is not a ground.
It's not
That is
here.
not a ground.
This my submission is the RFA.
That is your lookout. You catch hold of your counsel who are there. Who are there.
You have a remedy. Bar counsel.
RFA and trying to get this mistake. My way is remanded converted now.
We say nothing. This is not our
This
jurisdiction.
is not our jurisdiction. You have filed an RFA or whatever it is there, you pursue your.
My lords, if I may suggest, my lords, I could impress upon my client, my lords, that if my learned friend's client is also open, if there can be some sort of a discussion between the two parties, and if we can impress upon
Want to
his
put
client.
quietus to the whole thing because the monetary aspect of the decree.
And this is my difficulty. They don't come.
But what about that 25 lakhs? Is there any order for 25 lakhs?
Only 1 lakh, my lords. My lords,
Then it's only okay.
what aggrieves the party right now, my lords, is that he is not deleted any of
Okay,
these
you
posts.
want to think over it? You have heard her. She said, put quietus, if an apology, if he feels, we are not saying anything. That's not our call, it's your call. Just say that at the joint request of the council for the parties, re-notify.
Grateful.
18-9. Serial number 12.
For the appellant lordship. There is a office object.
Yes.
Lordship. There was an office objection regarding production of translation. We have already produced the translation. Same documents are produced by the objection. So my prayer is only limited to the court direction for 6 lakh rupees per petitioner, wherein no prayer is sought against me in the petition. However, the court has said that I have to deposit 6 lakh rupees. So on that limited aspect only, the challenge is before this honorable court. And all the documents which the petitioner has produced, the translations are produced. The respondent BDA has produced the same documents, and I am not relying on those documents. My only prayer is to set aside that portion of 6 lakh rupees which has been directed to be deposited.
But you have demolished that house.
No, lordship. That is my contention. Lordship may see the first paragraph of the petition filed by the petitioners. First, if your lordship may kindly go to first paragraph of the petition at page number, lordship, page number 50. Page number 50. If I may be permitted to read.
What is wrong in the judgment?
Lordship, may kindly go to page.
No, let's be very clear.
Yes, sir.
If the conduct, surely, how would you justify your conduct?
Lordship may kindly see the. Lordship may kindly go to page number 50. I'll explain this quote.
50?
Lordship may kindly go to page number 50.
Yes.
First paragraph of the petition. The petitioner submits that they are all residing at Arundhati Nagar slum, Chandra layout, by putting up sheds. In order to develop the new layout, Bangalore Development Authority has demolished the sheds. It is not we. It is the Bangalore Development BDA which has demolished the sheds of the petitioner with the assurance of granting alternative sites in their favor. For allotment of alternative sites, the BDA has also issued identity cards and so and so. The contention of the petitioner itself is that the BDA has demolished. We are the slum development board. After demolition, they have allotted separate sites wherein the slum development board has constructed an apartment for urban poor, basic services to urban poor. Now, because the slum development board is constructing that apartment, these petitioners went back to the BDA saying that the land has been taken over by the slum development board. They are constructing their apartment for urban poor, so grant us separate land. Subsequently, there is a meeting held between the Deputy Chief Minister, and the Minister for Housing. Everywhere, all these participate, BDA participate, they tell that alternative allot separate sites to them. The BDA allot separate sites to them. It notifies all those details. However, does not execute any sale deed to them. They file a representation to the BDA to execute a sale deeds in their favor. The BDA does not do. They approach this honorable court with a simpliciter mandamus directing the BDA to execute the sale deed. There is not even single ground against me. Nothing. No representation is given to me. Nothing has been conducted. But however, the court says that wrongly interprets that we have demolished. Your lordship may kindly see the order passed by the court.
So you see
Paragraph number 19 of the order, lordship.
PDA has demolished.
Yes, lordship. Paragraph number 19 at page number 33.
They say issue notice for the respondents. Returnable order. Office objections are there. Office objections, if any be removed before the next date of hearing. We give it 8.
17-9.
Obliged, lordship.
Weekend. Today we are having 60 matters we are having. Huh? You can still space the matters. So we have 50 matters. We can have 50 matters. Is it? Next.
Half of the list we can say as fresh matters. So that when they issue a notice.
That you do that. That's what you were suggesting.
List 1, list 2.
Fresh matters separate. 20.
ಅದಷ್ಟೊಂದು ನೋಟಿಸ್ ಹೋಗೋದು ಹಿಂದೆ ಏನು ಮಾಡೋದು
ಅದಕ್ಕೆ ಮೆಮೋಸ್ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
We give the date here. 13. Next.
Serial number 13, I appear for the appellants. Recently we have filed wakalat on 1/7/2025. My kindly grant us 2 weeks time to cure all the office objection, get the matter fresh before my lords.
Objections be cleared within 4 weeks. Yes, ma'am.
Here was passed in respect of 3 petitions, and your petition dismissed. 3 appeals were filed. Your 1 appeal already your order has been passed.
To the extra resolution. Compensation. Certain yardsticks given you as harmons are being taken. Say that announcement of person when he goes to a deputy commissioner, he goes 5 times.
Those are not the solution and other aspects. When it comes to actual compensation, everyone has a discriminable.
But what do you say on this?
Lords, all the conditions which we had raised before the single judge is that they're holding on to our land. Single judge, my lords. We are the National Highway Authority. They're holding on to our land in the name of public purposes. They are not even utilizing it. All that they're doing is they're doing real estate in the property which they have acquired. The authorities. That is our contention was, my lords. So basically in this order now they've considered the petrol pump has a public purpose and then they have passed an order. Whereas to my property, my lords may kindly look into it once and then my lords may pass any such orders. My lords.
This acquisition is also part of this acquisition.
Please, my lords. But the prop.
It's not just for petrol pump, it's for wayside amenities, and it's not like this property is for petrol pump, this property is for this.
My lords,
Total amenities, but they are not developed.
please, my lords. They're not developed. Yet to be developed.
Contract has already been entered, but they are not getting possession now. And that's why they are not able to do this, carry out this wayside amenities. But otherwise, contract has already been awarded. That's why
My lords, all.
Notifications, both the notifications have been issued,
Please, my lords.
preliminary and final.
Please, my lords.
Then what right you have?
My lords, all.
They use it or not,
Please, my lords.
it is their lookout,
But we were not paid the compensation, but single.
cutting there,
Please, my lords.
isn't it? Virtually, in their parlance. You are squatting there.
My lords, all that I was requesting before my lords is, my lords, I'll queue my office objection. My lords may kindly hear it on one on one date. It's enough. My
There
lords.
is no provision of denotification there.
My lords, we are not asking for
Where
the
is that?
denotification, my lords.
National Highway Authorities,
Please, my lords, they have encroached the land which is actually not required for the National Highway Authority, my lords.
see, that is not your case. You cannot have a say on that. When preliminary notification and final notification, both are,
At least they should be keeping the land pending for
have any
the
say.
National Highway Authority itself to use, my lords. They can't go proceed and give it to some other people by way of a real estate. That was my condition before the single gen. It's not been recorded. My lords.
Under the provision, and there is right to develop or wayside amenities. So it is about
My lords, all that I'm seeking is, my lords may hear on one hearing please, my lords.
When do you want, tell us?
My lords,
What do you want?
my lords may grant me 1 week time to queue the office objection. My lords, any date after that.
Weeks time to clear the office objections.
give this later.
Just give it later.
Achha.
Seventeen, 14.
Lord, I'm the complainant, my lord. My lord, I pray for a week's time, my lord.
Just shows. Why?
The complaint started to clear the logistic kindly see para 17 of the complaint there we have filed another writ petition because it's on court. The same came to be dismissed on 25 month 25, January 25.
Well, what happened to the Supreme Court?
It's still
Is it still pending?
Supreme Court has delegated the cost of it's 63 of the same number.
Okay, only to that extent.
It's 63. Figure number 5.
But otherwise the judgment left open. Question of left open.
It has to the allotment of C2. It's not like the other complaint was regarding the allotment of cost. That only to that extent they are succeeded before.
So what remains now?
Nothing remains. He has already done and he is going.
What do you want?
Lord, all,
What survives in this? Tell us.
Lord, all I pray for is a week's time, my Lord.
We'll give you 2 weeks.
My Lord,
But tell us the reason.
Lord, I'm in only position to tell this much, my Lord. My senior colleague is not well, and we have engaged a senior counsel, and he is not free today.
Oh, re-notify. You want 1, 2, 3, 4 weeks? Tell us. How many weeks?
2 weeks, my Lord.
2 weeks.
1/8,
At the request of counsel for the petitioner, adjourned to.
Much obliged.
15, Shri Krishnamurthy.
Okay, for complaint, my lords. In spite of service of notice, my lords, government says that, my lords, after 520 days delay, my lords, they filed the order writ appeal before this honorable court, my lords. And I received a notice recently in that proceedings. And in spite of service of notice in this contempt proceedings, my lords, accused number 2 is not appeared and they is not filing reply also, my lords. Your lords kindly see.
My lords,
it's
the
a medical.
state's appeal is scheduled on 11th of August, my lords.
Is it listed?
Date is given on 11th of August, my lords.
11th August?
Very much, my lords.
Because of this.
Against this impugnment?
Very much, my lords.
We'll have it on, just give him a copy of the appeal paper.
No, I appeared in that, my lords. 2 days back, I filed wakalat.
Oh.
Since December, my lords, they have not paid the PF. They are showing that number of the writ appeal, my lords, after 520 days delay. Because of this proceedings, my lords, my difficulty is that, my lords, since 2021, my lords, I am not getting NOC from the fire department, my lords. Because of that reason, the institutions, medical college and hospital, my lords, institutions license is not renewed, my lords, because of that. And all the facilities available to the patients in the hospital is not available. And facilities available to the students are not available. Since 2023, my lords, they don't file appeal and they accept it. Once I file a contempt petition before this honorable court, after 520 days, they file a writ appeal and they say that, my lords, we have filed a writ appeal, my lords. It's all that, my lords, I have to pay the fee.
This order is of 24.
24 reiteration of the 23 order, my lords. They are challenging the 23 order, my lords.
Now, you have not passed the order on the representation.
15/6/2023, my lords.
You have not passed any order because
You have not passed any order. Our appeal is listed on 11th of August, my lords. It may be kindly taken up on that day.
Just say that when did you file it? 25? Is it a 25?
24 months.
10, 12,
Writ appeal
2024,
1859 of 2020.
10/12/2024 writ appeal is filed.
We have been informed that a writ appeal has been filed of which of the order of which compliance is being sought. Re-notify, the date of hearing is 11th August. Re-notify this contempt on just immediately thereafter.
No, on the same date, my lords.
We'll have it after that. 12th or 13th August. 11th August also.
Sir, it will be posted before different courts, my lords.
So that's the reason we are not saying anything. It may be posted, we will see.
Please,
Really,
please.
You can tell us what happened in that appeal.
Please, my lords, please.
16, Shri A.J. Srinivasan.
I appear for the complainant, my lord.
I appear for the appeal.
They have to file their.
It complied with the order.
Just serve the copy, my lord.
Served a copy, my lord. We will verify, my lord.
The counsel for the has filed a compliance affidavit.
It's not a memo and that.
We want
I will,
by way of an affidavit.
I
Not,
apologize.
counsel must not say this.
I will get it.
Let the person officer must say. They have complied.
We have to looking into, my lord, just served morning.
But you file an affidavit.
Yes, sir.
Let the compliance affidavit be filed within 2 weeks.
Six, 8,
Much.
17,
I'm for the complaint in 17.
Same matter.
Lordship, in the-
16, 17, same month.
Same as 6.
6, 8,
6, 8.
18, serial number 18.
I'm for the complainant in this case. Government has to reply.
Yes, Mr. Chandrasekhar, what is your stand?
My lord, Saguvali cheat, I'll just share a copy, my lords, on 15/4/2025. We have issued the Saguvali cheat.
You have, we have that.
They have not received.
Does it complies the order?
It complies the order, my lords. Let them verify and state, my lords.
Just
At
give
the
it to
last
him.
occasion, there was no representation, hence I could not serve the same, my lords. I'll serve the same now.
Have you answered the representation?
That is for issuance of Saguvali cheat. That
Yes.
was their grievance, my lords.
I will verify.
Are you handing it over? Handing over?
The Saguvali cheat itself, my lords, the copy of the
Mr.
statement.
Chandrasekhar has handed over to the counsel for the petitioner the Saguvali chit.
Very much.
Yes,
my lords.
please.
The counsel for the petitioner seeks time to look into the same.
It's 11/8,
Please.
19. Received, Harala.
Yes.
Respondent office objection, my lords, in respect of the statement of objection filed. Office objection, my lord, I will comply. Statement of objection is filed, my lord. There is some- I
Respondent
have
number
to
6.
sign each and every page, my lord, that is the objection.
At the request of counsel for the, which respondent?
10th respondent.
For respondent number 10 to remove the office objection. Adjourn to. But have you carried out the inspection?
That has been done, my lords. Inspection has been done. Reports are, my lords, placed. my
Reports
lord.
are there. What are the report? What does the report say?
Reports have not been, my lords, handed over to my lords, both of the
Give
parties.
the report. Who has done the? Oh, this is legal services.
Please, please. My lord, along with the pollution control board, together joint inspection is conducted.
Ma'am, you have the report.
Pollution
No, we
Control
don't
Board has filed its report, your
My
lordship.
lord, report is there, my lord. The office may be directed to my lords.
A copy
supply
will
the
be served on
copies, my lords,
BBMP as
to
well, my lords.
all the parties, my lords, so that we can go through the report, my lords, and
Just sure that.
there were 2 inspection reports, my lords.
I also for the joint.
And the copies for the report.
Initially, the matter had come up before London.
Given to you.
No, my lords.
No, my lords, the reports have not been given to us.
Who has the report?
We have submitted results on the court. But we'll give a copy if they've not.
Just give them a copy.
I'll do that.
Copy of the inspection reports.
Lords,
Report, my lords, there's only one report. What has actually happened
lords,
is.
there
my
are
lords,
2 reports, my
The
lords.
matter, one second. The matter was registered before the single bench. my lords. There was a direction that the District Legal Service Authority should be conducting an inspection. So that report, my lords, have been filed directly in the court with copies to the other side. That copy even we don't have.
No,
When
that
we
copies
made
has
a
not been given to
court-
us.
When we made a mention to this court, my lords, they said, okay, leave aside that report, do a fresh inspection along with you, that is the case PCB, and
You give that report.
that report, my lords, we'll give it to them.
That is dated
20th March 2025.
20th March or 15th March?
15th or 28th.
That's 20th March.
20th March. Very well. Copy of the report dated 20th March
We'll hand it over to them.
2025.
To
Yes,
BBMP as well.
Be given to the.
All the parties.
Be given to the council for the parties.
Yes.
By respondent.
Six.
Six. You have four?
R5 and R6.
Five, respondent numbers 5 and 6.
Sorry, my lords, we thought the copy would have been served.
20th of March 25. Be given to the council for the parties. Give a date.
11/9.
Please.
This one.
Serial number 20.
The filing your reply.
20, yes, my lords. I'm serving the compliance affidavit. I'll file the compliance affidavit in
Compliance
registry.
affidavit be filed during the registry during the course of the day.
By tomorrow.
Rejoinder, if any, be filed.
Please. 7.
4 weeks.
14/8. Serial number 21. 21.
I appear for the. Lord, I'm filing the affidavit. Lord, as directed by the learned single judge, this survey was conducted and Lord, my apology, my lord, just yesterday we received the document. Those are in Kannada. If my lord have 1 week's time granted, I will just, my lord. Lord, here what has happened, my lord, petitioner had contended that some portion of land has been utilized for the road forming without acquisition. Now, as per this report, that is the fact. But extent, and petitioner was also present during the when survey was conducted, and there is it's a 16.5 kuntas has been utilized without acquisition. But now, defense ministry, there are two khatedars, petitioner, complainant herein, and the defense ministry. So both were called by doing the survey. So ministry also has claimed that they have more extent than what it shows in RTC. So Lord Tehsildar has been asked for to find out the correct ownership details by taking documents from defense ministry. So that they say give, Tehsildar is working on it, but he needs some more time.
How much?
So he said 1 week's time. Tehsildar said 1 week's time he will be able to tell.
So you know how much you have utilized without acquisition.
That we know.
So pass an award on that.
Lord,
Go ahead with that.
but in whose favor?
And in whosoever favor, whatever may be the extent that dispute, let it be.
Because it will be
decided.
consent award, so it will be sale deed. So we should know that who is the person in whose favor we have to execute sale. They have to execute sale deed and we have to make the payment. So for that consent sale deed.
No, we'll be able to know what the Tehsildar has done in 2 weeks.
No, that will be-
Within 2 weeks, hopefully, if not government. If Tehsildar may be directed to expedite.
Yes, Mr.
But
Chandrasekhar, you are role.
We'll cooperate. My lords.
It's good to hear.
Very much, my lords.
Just say this, Ms. Shah has, for accused number 1 and 2, has filed an affidavit. In the court, the same is taken on record. At her request, re-notify after 4 weeks.
I'm highly obliged.
22/8. Serial number 22. Shri Sunil Narayan.
Yesterday, the DC has passed an interesting law.
Report of 21, 20th of March 25 reported to be copy of the
Objections to the
We are at 22.
Yesterday, the DC has passed the order, sir. Share a copy of it.
I'll verify.
Yes. What have you?
Yesterday, the DC passed the order, sir. Share the copy.
I'll verify.
Mr. Chandrasekhar has handed over to the counsel for the petitioner the copy of the order passed by the DC. The counsel for the petitioner seeks time to look into the same.
Eighteen eight 23, Shri Mahesh Uppin, seal number 23.
This pertains to the NOC to be given to establishment of a petrol pump. We have processed, we did issue the NOC also. Then there was public complaints with respect to the situation of the petrol pump with respect of the road being narrow, there was a college situated, there was agitation where it was nothing to the same. So we have also issued a notice to the complainant hearing for a public inquiry which is scheduled on 17th of this month.
Lord, he issued NOC, Lord. For issuing NOC, Lord, he took Lord, nearly 6 months' time, Lord. Thereafter, he receives complaints from public, and within 1 day, he grants stay of his own NOC. He committed further contempt of the order passed by this honorable court, Lord.
He should have done it earlier, this public inquiry.
Lord, he has Lord, received.
Possibly realized his mistake. You should have done earlier.
Should have been prior to the issuance of it.
Lord, it was pending before him for.
That's right. You may be right in saying so. You should have done it. Just say that at the request of Mr. Chandrasekhar, we notify on. Will we get the result, this thing?
It's scheduled on 17th of July, Manoj, any time first week of August.
Just have it first week of August.
Finish it by that.
6-8, seal number 24, Shri Prasanna.
Yes.
But I am submitted the certified copy on 20th/6/2025. I produced the copy of certified copy on 20th June, my lord.
Yes.
And regarding the other objection, my lord, that is, I am put a note, my lord, within the in time, my lord, I filed the appeal. Office objection I kindly overruled.
But there are certain objection date of impugned order not reflected.
Well, that is
On filing of the certified copy.
On 20th itself I have produced the copy.
So you are saying you have removed all the objections?
Please, regarding the office objection, that I gave a note that the appeal has been filed within the 30 days. But office objection is date is not forthcoming in the impugned order. That is computer generated copy I produced initially. Now I am produced the certified copy. Well, that's why office objection may be removed.
But you have produced the certified copy?
Please, madam, please, on 20th I have.
They say that it's the office objection of the registry that the impugned order not reflected at page 13 of the commercial appeal is concerned. But when the counsel for the appellant states certified copy of the order has been produced.
Please.
And that be so, the objection is removed. Now what?
Regarding the main matter, the matter is referred to the Lok Adalat in the trial court, and that is set on 12th.
What do you say, ma'am? Already referred?
Referred in trial court, my lord, that is matter is referred.
Okay.
This way at next week.
Just say that we have been informed that the parties have been referred to Lok Adalat, scheduled on 12th of July 2025. That be so, re-notify on. Just give it in August.
20th August. 25, Shri Manu Prathan.
Let them just take steps, my lords.
already acquired. And what is the direction here?
Direction is, my lord, to accept the tax.
If I may briefly bring out my lords, the VDA had acquired the land, my lords, but deposited the award after a lapse of 25 years. The complainant herein, my lords, filed a writ petition. The writ petition came to be partly allowed, directing the VDA to pay 12% interest on the award amount. Not satisfied, my lords, they filed an appeal, my lords, where the acquisition came to be quashed. We went on an appeal before in the SLP, my lords. There also we lost. Now they were before the writ court seeking a direction to give an NOC from the VDA to direct the DBMP to issue the carta and accept the tax. But that also has come to be allowed. It was a mandamus, my lord, that has come to be allowed. Now the question here is, we have acquired the land, put it in our map, my lords, the layout map, and the award alone was deposited a little later, my lords, after a lapse of 25 years. So now we are seeking some instructions from the government. 4 weeks accommodation, my lords, I'll place it on record.
Yes, sir, the request of counsel for the BDM.
PDA.
PDA, please.
Lord, all I am submitting is that a writ appeal was filed. It was held in my favor. They filed SLP. SLP is rejected. Therefore, acquisition is now set aside. I am saying, my lords, the only thing is now I am saying, allow me to pay tax, allow me to develop the land. Nothing more.
They are doing it. Let them come here.
Please.
What can they say now when the matter has attained finality till Supreme Court?
Perhaps,
Let him take instruction. What is it?
Please.
It's a matter of time now.
please. Great.
21-8. Seal number 26. Chandranath Tariga.
For the appellant in this case, Lords, the office has had raised one objection that 67 and 69 are not legible. Lords, those are all office notes, my lords. We are not relying on that, my lords. I'm not relying on that.
Then a counsel for the appellant states he shall not rely upon pages 67 and 69.
Yes, my lord.
If that be so, come issue notice.
My lords, if I may, my lords. The order under challenge, my lords, is an order passed under Order 7 Rule 10.
Couldn't you show us that CPC?
My lords,
The order was passed by regular court or
the commercial court, my lords.
commercial?
Issue notice.
My lords, pressing for stay, my lords.
Stay of what?
Stay of the order passed by the.
There is no suit at all.
My lords,
What is
indeed.
to be stayed?
My lords, if I may, my lords, if my lords were issuing notice, my lords, may I seek for an order, my lords, wherein I may be permitted to appear before the trial court and trial court may dispose it of in
Inside this issue, we will not.
date may be fixed, my
We are
lords.
fixing it.
And I may be permitted to serve on the counsel for the
Issue
Respondents.
notice. Liberty is also with the counsel for the appellant to serve the counsel for the respondents who appeared before the trial.
grateful. Date may be fixed.
7-8.
Grateful.
27.
Batch of proceedings, my lord, in 27, my lord, service is awaited.
I am undertaking to file wakalat at 27 and 27.1.
Both.
And also 28 also. I am already filed the wakalat on behalf of 28.1 and 28.2.
What is it?
Just say that so and so appears for the respondent. So it states that he shall file his wakalat within 1 week. So I just show the others.
28, my lord, it's come for consideration of delay 208 days delay is there, my lord.
Do you have any objection on that?
It may be correct.
Delay in all, these are all 208.
Yes, my lord. All of them.
208 condone for the reasons stated in this. And in the second one, 469 27.1, he appears for respondents number 1, 2, and 3. All the 3 respondents, 4, 5.
Yes.
5.
Yes.
Accept notice, says Wakalat will be filed. Delay condone. Delay condone. And similarly in 28.1 also.
And I have sought stay, may be posted on time, my lord, for consideration.
Have they initiated any?
No, no, not yet,
No,
not yet.
no.
They've issued a notice.
So by judgment by this honorable court, my lord, this-
They've issued notice.
Give me another one.
My lord, they were, these respondents, my lord, are gangmen.
For how many years they have worked?
Lord, each year, my lord, 15 days, 20 days, 30 days. Lord, they are gangmen. Monsoon gangmen.
Days? No, in total.
My lord,
What we are saying is cumulatively, how many days they have worked?
Lord, in each case,
How many years they have worked?
Lord, 4 years is what, Lord, in each case, Lord, the labor court, my lord, went into this issue, recorded a finding that in none of the years it is for 240 days. Even cumulatively, my lord, it will not be 240 days. Therefore, my lord, their request for, Lord, reinstatement, etc., all that was rejected. Lord, when High Court, my lord, considering it, learned single judge, says, my lord, question of reinstatement will not arise, relies on, my lord, BSNL's judgment to say that you compensate. But that was a case where there was a finding that they had, my lord, they were employed for more than 240 days in each year.
But and then one thing very well. The only thing is they may not have the requirement to follow 25F.
F.
That's all. But for continuously for how many years? And mind it,
Lord, it's
was it an artificial break?
No, 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 my lord. What happens, my lord, is during monsoon, I need some, my lord, manpower to prune, my lord, the trees, which.
Then tell us one thing very well. You want to take time, look into it.
I want it.
Oh. 28.1 also.
Yes.
This.
28.1 and 28.2 that filed Wakalat.
It is so and so accept notice for the response.
Ten nine.
Give the date.
10-9. 10-9.
Good.
Serial number 29.
No, I appear for the appellant.
The
My lord, what
contesting
is called in question, 69.1 is our, what is called in question, my lord, before your lordship, is the order of the learned single judge, by which, my lord, certain rules called the green energy open access rules, framed by the Ministry of Power, Government of India, has been quashed. Consequently, my lord, the regulations framed by the Karnataka Electricity Regulatory Commission has also been quashed. Now, my lord, the only question that arises for your lordship's consideration in this appeal is, that is the ground on which, my lord, the learned single judge has also quashed these rules, is whether the rules framed by the Ministry of Power, Government of India, is ultra vires section 42(2) of the Electricity Act. Now, my lord, please look at section 42(2) for a minute. And on a plain reading of 42(2), my lord, the conclusion arrived at, it is my respectful and humble submission to your lordship, the conclusion arrived at by the learned single judge is erroneous. Kindly see 42(2). My lord, this relates to what is called as open access. As your lordships are aware, my lord, under the Electricity Act, generating company does not need a license. I, as a generating company, I am entitled to enter into a PPA directly with a consumer, a large bulk consumer. I can enter into. Now, my lord, the power has to be transmitted from my generating company to that consumer. My lord, there are two ways of doing it. I set up my own transmission lines, which is, my lord, impractical proposition. Now there are the transmission lines, the poles, the transformer, everything set up by, in Karnataka, what is called as the Karnataka Power Transmission Corporation Limited, KPTCL. Now, my lord, the entire object of the Electricity Act, namely to augment the generation of power, will be defeated if you put an obstacle to the free flow of electricity from generating company to the consumer. Because your lordships are aware, my lord, the power which is generated can never be stored. It has to be used. Either you shut off your plant, or once the plant is working and power is generated, you have to ensure that there is free flow of power through the lines to the consumer. Therefore, my lord, if ultimately the object of the Electricity Act is to ensure that there is no shortage of power at the end, namely at the consumer's point, not only should you increase generating capacity, you also should allow free flow of power through the transmission lines. Otherwise, the whole object of this act will go. Therefore, my lord, as a policy, they came up with what is called as open access. Open access simply means that the facilities that are available, namely the line, the poles, the transformer, are all freely available to every generating company to wheel the power from the generating station to the consumer, subject of course to technical limitations. That is the whole object behind the Electricity Act. Now please see, my lord, 42.2. May I read 42.1 and then 42.2 of the Electricity Act.
Yes.
It shall be the duty of a distribution licensee to develop and maintain an efficient, coordinated and economical distribution system in his area of supply, and to supply electricity in accordance with the provisions contained in this act. The State Commission shall introduce open access in such phases and subject to such conditions, including cross subsidies and other operational constraints, as may be specified within 1 year of the appointed date by it, and in specifying the extent of open access in successive phases, and in determining the charges for wheeling, it shall have due regard to all relevant factors, including such cross subsidies and other operational constraints. Now, what the learned single judge says, my lord, is that the power under 42.2 is vested with the State Commission, and therefore the central government could not have framed these rules. And the regulations that have been framed by the Electricity Regulatory Commission simply follows the rules that have been made by the central government, and therefore there is no independent application of mind by the Regulatory Commission, the State Commission, in the matter of formulating the regulations. Therefore, my lord, both the rules and the regulations are bad, is what the learned single judge says. This is a short point for your lordship's consideration. The question, my lord, simply is whether 42.2 is exhaustive. Can we read 42.2 in a manner to say that in respect of every aspect of open access, it is the State Commission alone which has the power, or is it with respect to certain aspects of open access where the State Commission has the power, and with respect to others, the rule-making power of the central government prevails? This is the short. And now, my lord, under the Electricity Act, we have several authorities. My lord, we have the concept of what is called the appropriate government, which could be the state governments, it could be the central government. Then we have the Central Electricity Authority. Then we have the State Regulatory Commissions. We have the Central Electricity Regulatory Commission. We have the State Load Dispatch Center. We have the Regional Load Dispatch Center. Each one have their roles to play. And here is a case where the policy, electricity policy and the tariff policy, my lord, has to be framed by the central government. And the regulatory commissions are to follow those policies. So can it be said that with respect to every aspect of open access, the power is vested only with the State Commission, and the central government is divested of all the power. This, my lord, is the question.
But the 42 itself has been set aside.
My lord, I'm sorry, my lord.
42 has
No,
been-
no, 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 my lord.
42 is very well. 42 stands
Yes,
and the rules made by the
is
central
the
government.
ultra virus 42. That is the question. And now, my lord, the rules, there is one particular aspect I want to point out, your lordship. The rules provide for what is called as the banking charges. Banking, my lord, is nothing to do with open access.
But how would you read this as may be specified within 1 year?
It is with respect to certain aspects of open access, not generally.
But who would do that?
State Commission.
My lord, with respect to those aspects which are specified in 42(2), it is the State Commission, no difficulty about it. But with respect to matters not specified under 42, but it may relate to open access, or it may not relate to open access, it is only the central government by virtue of the rule making power.
So the open access is not confined to the State Commission.
No, that's what I'm saying, my lord. I am saying open access is not confined in all its gamut with the State Commission. There are certain aspects of open access which are to be regulated by the central government in exercise of the rule making power under section 176.
So the finding of the learned judge is
Omnibus.
that no central government has no power
Yes, yes,
for open access.
yes. That is the finding of the learned judge.
Even outside a particular.
Yes, man. That is what we are saying. That is exactly what we are saying.
Now, how would we want to understand what is this open access system?
Well, as I explained to your lordship, I tell you lordship, it is defined, but I'm sorry.
Using the grid which is there by the different different generating companies, maybe private or maybe
Yes, yes,
state-owned.
yes.
So
To reach the consumer's place.
I believe that this grid will operate.
Yes.
And that will supply to these Bescoms, Hescoms, etc., etc. They will be, the last mile connectivity will be done by them.
In fact, where it is open access, I can have supply of electricity directly to the consumer's point.
You can inject it into the
Yes,
grid.
yes. That's point. Your lordships are right. I bow down to what your lordship is saying.
So the how it should be regulated is the job of this
State Commission.
The rules come under 42A.
42.
So your contention would be, that's what I presume, maybe.
Yes.
Please correct me if I am wrong. There are grids which at the national level and the grids at the state level also.
Absolutely.
And therefore you may say that the rules or regulations under 42 by the central government is also needed.
Yes. That is one absolutely, my lord. Yes, my lord, that is one aspect of it. Very, I bow down, my lord, because where it is an interstate, necessarily it should be central government. That is one issue, my lord. The other issue that your lordships will have to look at is, now, for example, my lord, the rules provide for what is called as the banking charges. Now, I ask myself, where under 42(2) is banking charges covered? Kindly look at the rules for a minute, my lord. I showed your lordships where the banking charges is provided. Very well.
In the meantime, my lord, I wanted to point out two things. One is, my lord, we had requested the central government to notify all others. Suppose, my lord, my learned friend's petition writ appeal is allowed. Then what happens, my lord? The single judge's order goes, and we have to pay all the charges. Generators have to pay all the charges as if, my lord, we were to pay under the GOA regulations. Presently, what has happened, my lord, because of the quashment of those GOA regulations, no charges are leviable. Only, my lord, 50% of the charges were allowed to be paid. I'll complete my submission.
Let me complete.
So
please.
therefore, I am requesting, my lord, the central government.
That is in respect of the charges which you have to pay for using the grid.
Yes, that, my lord, now that is one aspect. The lordships may see the impugned order at page 47, my lord.
Are you proceeding on a premise, if assuming for a moment this appeal is allowed?
Yes.
The consequence of the appeal
is revival of those regulations.
Must be now done by the central government.
Yes.
Sorry, no, and
Must be done now.
yes. No,
Pending
it-
hearing
no,
of
the rules were framed, regulations were framed. They were struck down by the learned single judge saying that, my lord, there is no legislative competence. Now, if they are revived or my lord even stayed, then along with those regulations and rules, charges will also revive.
That's right.
And therefore they will be impacted. We, my lord, sought the quashment of the charges based on the fact that these regulations should be quashed. Our whole intent was, my lord, the charges were levied.
What happened?
We succeeded, my lord, before the learned single judge.
To the extent of the provision getting set aside.
Yes, and the charges also, my lord, levied for that period under those repealed regulations were not
No.
struck down regulations.
Can I point out one
And
fact? Your Lordship?
therefore,
After, oh, I'm sorry.
and
Lord.
therefore,
I
my lord,
apologize.
they are all necessary parties is one submission. Secondly, my lord, much water has flown after that, and kindly see, my lord, in the writ appeal, the new regulations have been made by the KERC. Page 395, my lord.
My lord, yes, my lord. Now, my lord, new regulations have.
I'll complete myself.
Your challenge is only in respect of the tariff.
No, we are saying, Lord, they had no legislative in fact, the rules made by the central government mandated that the state commission's regulation should be attuned in line with the rules made. The central government tried to say that these are the umbrella legislation. You align your regulations in line with the rules that I have made. So we, my lord, we hit at the very root of the matter. We said the main regulations itself should go, rules should go. And my lord, we succeeded. And now, my lord, KERC has made a new regulation, which is consistent or inconsistent with whatever, my lord, is the fact. Now, in the writ appeal, they have prayed that those regulations should also be struck down as a consequence.
No. My learned friend, I just want to say something in support of what my learned friend is saying. My lord, insofar as 2025 regulation is concerned, my lord, I quite understand, my lord, that I can't ask for striking around those 2025 regulations in the writ appeal. My lord, your lordships may omit that prayer from consideration. Is a submission I'm making. Now, my lord, I want your lordships to kindly turn to page 198. I tell you, lordships, what is the interim order I'm seeking? Please be kind enough to turn to page 198, my lord, para 200.
So what is the interim order?
I tell you, lordship. In fact, I am not asking for anything more than what the learned single judge has said. Kindly see, my lord, take para 201. Taking cognizance of the fact that this order would leave a vacuum till regulations are framed by the KERC independently as observed above, an interim arrangement would therefore have to be made to ensure that the wheeling and banking facilities availed hitherto by the petitioners are facilitated. I pause for a moment here to point out your lordships. This 2025 regulations has been challenged by somebody, for some other generating companies, and this honorable court has stayed the 2025 regulations.
In which matter?
Well, in another writ petition. Now, my lord, so therefore, today we are in a situation where the old regulations framed by the central government quashed, new regulations framed by the state, interim, what is to happen? Now, my lord, the learned single judge contemplated that position. Therefore, my lord, make some interim arrangement. The commission, my lord, made an interim arrangement. Your lordship gets it, my lord, at page 391. I am saying, please let that interim arrangement continue. Please see page 391, my lord. I am saying, let this interim arrangement, otherwise there will be a vacuum today. Old rules gone, new rules stayed. That's the difficulty we have now, my lord. Therefore, let the interim arrangement as contemplated by the learned single judge, as framed by the commission, continue.
Does the learned single judge say anything on that interim arrangement?
Yes, my lord. Yes, my lord. Yes, my lord. Please. My lord.
That will hold.
No,
No, my lord. Let it continue. Let it continue. That's all I'm
That should
saying.
continue, my lord. He's right. Why? Because the regulations that are made now, my lord, there is total confusion. The new regulations say they take retrospective effect, and he's also right in saying those regulations are also stayed in the interim order somewhere, and they have said retrospective effect shall not
I
be
think
given.
both
There
of
is
us
a
are
chaos.
saying the same thing, my lord.
We are saying
Both
the
of us
same
are saying the
thing. We are
same
saying the
thing.
same
So
thing.
therefore, my lord, today your lordships may do one thing,
Yes,
my
my
lord.
lord. I completely support, my lord, what my learned senior says.
Let us,
That interim arrangement has.
my lord, 391.
391.
Yes.
Say KERC letter.
Yes, my lord.
Yes.
21st of January 2025, interim arrangement was made by the KERC. They think now the old regulations, the old rules have been quashed, the old regulations have been quashed. I am yet to make a new set of regulations. In the interim, what is to be done? Learned single judge says make an interim arrangement. I am making an interim arrangement in terms of page 391.
No, which part of it?
My lord, please be kind enough to turn to page 391. My lord, I'll read that for your lordships. Inviting reference to the subject mentioned above, the validity of the electricity promoting renewable energy through green energy, that is the rules, my lord, framed by the central government and the Karnataka Electricity Regulatory Commission.
Come to 393, Mr. Raj.
Yes.
Therefore, in the matter of interim arrangement for implementation of open access from this till finalization of the ERC regulation.
Yes.
To inform you, KPTCL, this, execute interim wheeling and bank.
Yes.
And to implement the order of the Honorable High Court.
Let,
393, my lord. Correct.
Yes.
Well, let that continue.
yes.
Now, your lordship may kindly say
Yes.
one thing, my lord. The order the learned.
Take this.
No.
Nobody has
there
stayed.
is no
Now,
stay.
my lord, what has happened is.
No, no.
There's
No,
a
no, no,
confusion
I
now.
will explain.
But one minute, if you don't mind.
I am for the commission, but I have one submission. This letter is prior to the framing of the regulation of 2020.
That's right.
Yes.
Now
Correct.
2025 have come, 2025 have
Yes,
come.
correct.
Ah.
Yes.
That is stayed.
Stayed.
Yes.
No, there is no clarity on that.
There is no clarity.
No, no,
We
I
don't know.
completely support, my lord. There is complete chaos. No, let this arrangement continue, my lord. We'll argue the other matters later.
But there is a stay order. I pass on the stay order to your lordship.
No, no, our own.
ಇಲ್ಲ ನಿಮ್ದಲ್ಲಿ ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವಿಟಿ ಸೆಂಡ್ ಮಾಡಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಅದು ಎಲ್ಲ ಫುಲ್ ಅಷ್ಟೇ
ಅದೇ fully, no, my lord,
Fully
even
stayed.
if fully stayed, correct, my lord. He is right.
What is the subject matter of this appeal?
It-
All regulations?
yes my lord,
That's all?
yes my lord.
Is there anything said by the learned single judge on these regulations or this
No, no,
aspect?
the new,
2025 no,
no, no, no. That
Objection.
is a subsequent development, my lord.
subsequent.
Would you be, we don't know who are there, the parties in that writ petition where. it has
Some
been said
generating companies have
They are all
generated, my lord.
I represent most of them, all of them.
With there,
Yes.
you are the person.
Guilty. The culprit is here.
The
my
stay
lord.
is also, my lord, at our instance only, there is no clarity.
He is the person who went there, now he is now in coming support of you.
No, 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 my lord. We are all on the same page. I am saying, Lord.
1 minute, Mr. Prabhu.
Yes.
This is what this observation is pending the new regulations are drafted.
Correct, my lord. Correct, my lord.
Correct, correct, correct,
my
correct,
lord.
correct.
Now,
Correct,
new regulations have been drafted.
Drafted
also
and
come
stayed
into
also.
force, stayed also.
Stayed also. That's absolutely.
New regulation drafted, this will come, loses its effect. It was still the new regulations,
Yes,
225.
Correct.
Then it loses this effect.
yes.
This, correct, my lord.
That is why your
Correct,
lordship
correct.
has to pass an order.
Correct.
Will that writ petition will be the place for you to seek a clarification?
No, my lord, your lordships can do. Your lordship.
Now, this process need to be
No,
revived.
no, my lord. Till
Your
you are-
lordships can do it, my lord, because now, my lord, you know, as an interim measure, now that I'm asking for stay of the order of the learned single judge. So, for my lord, if I'm asking for stay of the order of the learned single judge, the old regulations will revive. If the old regulations revive, there is a confusion. Therefore, my lord, I'm saying, your lordships may issue a direction that till the 2025 regulations are
Consider.
given effect to, or till this writ appeal is disposed of, where your lordships are going to decide as to whether the old regulations are rules are valid or not, the open access will be regulated by the interim arrangement that has been made by the commission.
Yes.
Mr. Raghavan, what was challenged in this appeal was
Old. Yes, ma'am, I agree.
this batch of petition was not concerned with the new,
No, ma'am, not at all.
nor was it concerned with this communication of 21/1/25.
No, ma'am, not at
It
all.
was not
Not
part.
at all, not at all.
No,
Let this be a part.
So
of-
interim
may I-
arrangement, my lord, it can be an interim.
May-
Your
may I,
lordships
my
can
lord,
always
so-
modulate.
Mr. Raghavan, then it will create more confusion.
No, no.
Let's be very clear. 1 minute, please. Then this aspect becomes a subject matter of this appeal also. 25 will become a subject matter of this appeal also, which was not.
It is not. I bow down.
Why should we say something which has been said pending framing of 2025? This would be the position. And this was come in January 25.
Yes.
And when is the impugned order?
December 24.
Correct.
December 24.
You don't say anything. Possibly you may have to think in that writ petition.
No, there is an interim order, my lord,
You must
but
impress upon the court. You have stated, but what is an interregnum?
No, the-
This was what provided in the interregnum.
no, they overreach the, no, my lord, page 403, what they do.
We say nothing. Otherwise, we'll create more confusion.
No, but there should be some arrangement in the interregnum.
Lord, may make some.
Okay, court.
Your lordship, I appeal for
I'm the main party
KPTCL in
here.
these matters. I'm a practical lordship.
I'm the main party here. It is my rules which have been set aside. And, my lord, to answer your lordship's question on open access, I've got a easy to understand analogy. Let us compare the electricity infrastructure to a road infrastructure. Let us say the lines, the lines, electricity lines are roads. The substations are the bus stations. And let us say only the state is operating transportation from point A to point B. the state operates on the road and uses the bus station. Now, private parties are allowed, but they cannot construct their own road, their own bus station, but have to use the roads and the bus station constructed by the state. It's exactly similar analogy. There are private generators, but they will have to use the transmission infrastructure which is put up by the state. Now, permitting that is called open access. Giving access to that is called open access. Now, there was an international treaty under which all countries, India is a signatory. All of us have agreed, but 2070, we have to bring our to net zero emission. Now, in that regard, we are giving a push to green energy generation. Now, to do that, each state has got different regulations. They call by different names. There is no procedure. So we created a very broad rules without determining what should be the tariff. We left all that to the Electricity Regulatory Commission. We came out with a very broad rule. Like we said, there shall be a single window agency. There shall be a nodal officer. All applications should be in this format. We did not determine what should be the tariff. We did not jump into the exclusive domain of the Electricity Commission. Although this was not in violation of section 42, learned single judges set them aside. To that extent, learned single judge is absolutely wrong.
The concern what Mr. Arvan is expressing is, but possibly was not subject matter. It was not subject matter.
It was not. But
Subsequent of what now?
no, my lord, the impugned order, if your lordship stays the impugned order.
Open access regulations are under impasse. That, my lord, is a debatable question whether it is completely stayed, retrospective effect is stayed, or totally stayed. And one hand, my lord, we have no guidance. This regulation also takes a retrospective effect and says.
Whose behest it was stayed?
Which one? No, the regulations, my lord, we had no other go.
So very well, we don't know. Now you are arguing that at least what has been said on 25(1) should get revised. Though 25 has been stayed, but this must get revised. But that you must.
No, right recourse is to challenge it independently.
But there is.
We don't say anything.
But there is one other.
Not subject matter of this appeal.
But there is another way of looking at it, my lord, possibly which will give your lordships a power to pass an order, even though I see what your lordships are saying, that the old, what was in contest before the learned single judge was only the old rules, the old regulations, and not the new regulations that have been framed. Now, my lord, the 25(1)2025 was not an independent act of the Regulatory Commission. It was a action that was taken pursuant to direction issued by the learned single judge. Please be kind enough to see that conclusion, my lord, at page 198. Now, all the time, therefore, my lord, that the commission, your lordships may not even say anything about 25(1)2025. Your lordship can say, my lord, that's my respectful submission, that the interim direction at para 201 shall be implemented by the commission pending disposal of this writ appeal, having regard to the peculiar circumstances in which it is placed, where the 2025 regulations have been stayed by the Honorable High Court.
Yes.
We will read that paragraph at page 393.
At page 199.
393.
390. Yes, my lord. Yes, my lord. Yes, my lord, I will. Therefore, in the matter of interim arrangement for implementation of open access from 20th of December 2024 till finalization of KERC regulations 2025, I am directed to inform KPTCL, SLDC, ESCOMs, HRECs to execute an interim wheeling and banking agreement to implement the order of the Honorable High Court of Karnataka by using the latest standard wheeling and banking agreement, duly collecting the following: 50% of monthly charges, etc., my lord. After finalization of the Karnataka Electricity Regulatory Commission's 2025 regulations, modified WBA shall be executed for such wheeling and banking agreements executed in interim period, subject to the terms and conditions of the open new access regulations to be notified. Now, it is as good as 2025 not being there because of the stay order.
Yes.
It is eclipsed. So therefore, my lord, since this 20th of January 2025 interim arrangement is not an independent act of the commission.
Mr. Raghavan, but who has stayed 25?
No.
That court has stayed 25.
No, but whatever it is, my lord, the effect is. Sorry.
Okay, Mr. Prabhu, you will say, look here, I am seeking 25 stay, but there should be some mechanism.
No, what
What was provided is pending those rules are framed. This would be the mechanism in terms of learner single judge order.
Correct, but that is
No,
eclipsed.
my lord,
now.
there are two
By
parties. Sorry.
The stay order is eclipsed. The 2025 regulations. That is the effect of stay as your lordships have declared. It is eclipsed.
So you would say to that
Ah.
court, so at least that.
Let this be
mechanism
continued.
revived.
Correct.
But since this is part of the learned single judge's order, which is now being scrutinized by your lordships in appeal, I would respectfully submit, my lord, that it can be said that the interim arrangement is also a matter which your lordships can regulate in appeal.
That interim arrangement has been given effect to Mr. Raghavan.
But with the eclipsing of the 2025,
That's right, because of that stay order.
yes, well, that's there. Yes,
All that he's asking, Lord, since
This order has been implemented, which is under challenge. Here, other scope is whether it could have set aside that rules under 42, stating that it's ultra virus.
Well, may I then suggest this, my lord? If one more submission I'll make, my lord, and leave it at that. My lord, your lordship may stay this order of the learned single judge. So that, my lord, so that if the order of the learned single judge is stayed, I'm not saying it will revive. I know, my lord, if once the order is.
This is stay. Now, who has framed?
I have
25? Who has framed?
Commission has framed it.
no, automatically
Commission
there is
has-
an occupied field. Now, my lord, that's
I'm
the
saying now if it is stayed, then my lord, the interim arrangement. No, my lord, it may not be that way, my lord, because once it
Your
is,
Lordship, may I
once,
submit? I appear for
once it is
KPTCL in
quashed,
this matters.
once it
appear
is
for
quashed,
distribution licenses and
whether
the
a
transmission
stay
license in
will
this matter.
revive a quashed regulation, rule or statute, my lord, I would personally think it does not.
Well, then there would be, if that is so, Mr. Raghavan, what is the effect of stay then?
Effect of stay, my lord, is quashing is stayed, and therefore interim arrangement can, your lordships can continue. As part of the stay order is a condition for granting stay.
What will happen to the old rule of the central government rules?
No, they are already structured.
It's set aside.
That has been set aside. Your lordship may stay that, but then say those rules will not be given effect to because of the interim arrangement.
I think we should not create confusion.
My lord, till then there is such a confusion, my lord. Which is to be, what is to be, how is it?
No,
to be
I will
regulated?
only, no.
Your Lordship, may I clarify?
last
I
person.
appear for transmission licenses in these
No,
matters.
may I make
There's
this
so
last
much of
submission?
confusion
Lord?
today.
May I clarify, Your Lordship? I am collecting the transmission charges.
Why we not, no, on the basis, we need to understand what is this.
Of course.
No,
of
my
course,
lord, if
I-
the
I-
writ appeal succeeds, automatically, my lord, the subsequent actions taken, they are all sub judice in a way, my lord, indirectly, the subsequent regulations made in 2025 will also go if the writ appeal succeeds. Therefore, my lord, what learned senior is saying is correct.
No, may I clarify, Your Lordship?
Automatically, because that will revive. Now, my lord, the rules, if the central government rules, central government regulations revive, then automatically, my lord, there is no occasion for KERC to frame the subsequent regulations.
But now he says central government rules will revive.
So therefore, under the interim
No,
arrangement,
central government rules will revive if the order is set aside.
That's right.
But
that is under
But if it
adjudication.
is
Please make an
stayed-
alternative arrangement.
But if it is stayed, it won't revive. That's my understanding of the law. Because a stay,
Your Lordship,
well,
may I-
once it is set aside,
clarification.
Let's hear him. Yes, what do you want to say?
Your Lordship, I appear for the transmission licenses in this matter, Your Lordship. So, Your Lordship, the transmission licenses and the distribution licenses for the KPTCL and ESCOMs in this matter.
Yes.
Your Lordship, in the previous matter where a challenge was made to the rules 2022 and the regulations 2023, the stay was given on the basis that the rules are ultra virus, and we were made to collect 50% of the transmission charges. We were collecting 50% of the transmission charges as per the stay order, and a direction was given to the KERC to frame new regulations independent of the rules. And now new regulations have been framed, which have again been challenged in 25 to 30 cases by various generators before this honorable court. And if they have obtained an interim order and in those matters with a complete stay, then I'm not liable to, I'm not entitled to recover any transmission charges. So there should not be any, they should not be aggrieved. But Your Lordship, in all those 25
He's
to
saying,
30
I cannot collect any charges.
Your
So make
Lordship,
an
let me
interim
complete.
arrangement. That's what he's
Let me
supporting.
complete. No, no. Your Lordship,
That's all he's saying.
Your Lordship, he is misleading.
That may be recorded, and he's right.
No.
Because
No,
once
no,
those
Your Lordship,
regulations
let me
are
complete.
made, we are not
Let me
Lord,
complete.
on any
Let me
finance
complete, Your
fiscal
Lordship.
debate.
I
We are only
request
saying,
Your
Lord, what
Lordship,
should be the interregnum
let him
arrangement?
not
He should also
intervene,
not
Your
suffer. We should also not
No,
suffer.
Your Lordship,
and
I'm not saying
everything
that.
is vacuum now.
No, I am not saying that. I'm saying, Your Lordship, if they have obtained an interim order, they have not, Your Lordship, in the
Correct. We want him to
25, 30
succeed, but let
in
Lord,
all-
let there be arrangement.
all 25, 30 matters, Your Lordship, I may be given 1 minute.
Yes.
I may be given 1 minute, Your Lordship.
Your lordship may give a short date, my lord, shortest possible, whatever time,
Yes.
subject to your lordship's diary, my lord, subject to your lordship's diary.
My lords, kindly, my lords, I filed an application seeking to come on record, my lords. I was one of the petitioners before the learned single judge. I'm not a party in the writ appeal, my lords. IA number 7 of 2025.
All those parties, my lord, who are before the single judge should also be notified.
Notified, my lords.
Through the council or otherwise also, because otherwise, my lord, what happens is the impact will be universal. The charges were quashed, regulations were quashed. They are not before your lordships. What my learned friend has done is, my lord, in my writ petition, they have sought leave to appeal and they are before, they are right. But the union should have made all of them as
I
parties.
see the point. I think I'll have to take on notice to
No,
all
not him, my
those-
lord. The union, let union take. They have every right to.
This is common to all the appeals?
Yes, yes.
Where all have not been made parties?
No, no, my lord.
Then Mr. Kamath, you and Mr. Raghavan possibly have to instruct the briefing officer.
My lord, I'll discuss that. I'll take some
Just say
action.
we just.
Because they are all, my lord.
Of course, my lord,
affected
without notice to them, I can't, I understand, my lord. Because in the writ appeal, my lord, as I can see, we have made, my lord, not all of them as parties.
parties. One has been made the
We have
lead
made, my
petitioner.
lord, we have made one hydropower company as a party,
That was
and
the
then
lead
all of them, rest of them are all
Not
authorities.
parties. I'm one of the petitioners in there.
He was also there. Then,
I filed my
there are
application,
other
which is on record, my lords. IA number 7 of 2025.
Yes.
That may be allowed today.
His application.
My
should be
application may
allowed.
be allowed today, my lords. The rest of them.
Making you party.
Very well, my lords.
That may be recorded.
No, but we just want to, it's only an amended of memo of parties is required.
Only memo of parties, only memo of parties and
They
notice.
should be notified.
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 Noticed.
Issue notice.
Yes, my lord. Your lordships may permit, on my oral request, please permit me to implead all those who were petitioners in the writ petition as respondents in the present case, and your lordships may direct notice, my lord.
Just say that,
Same is the case with union also.
just say this, that they have been informed that all the petitioners who were there before all the companies which were petitioners before the learned single judge have not been made parties.
In different
This
petitions.
writ appeal. Mr. Raghavan and a senior counsel appearing in WA 515 of 2025 on instructions submit that on his oral submission, the appellants be granted permission to implead all the companies who were writ petitioners before
Yes.
the learned single judge. This request is allowed, amended memo of parties be filed within
My lord, we will do it
They
in
should
the
be
next.
notified.
within a week.
Tomorrow, we'll do it tomorrow, my lord. No difficult.
But they should be notified. my lord.
Along with copies of the appeal, my lords.
Within 2 days, on filing of the amended memo of parties, notice shall be issued to
Yes.
the newly pleaded respondents. And including the counsel who appear for those companies.
Grateful.
Before the learned single judge.
Grateful.
Along with copies of the appeal, my lords, if I can.
With a by.
Annexures.
You are sailing in the same boat, no?
Please,
By furnishing him a copy of the appeal paper. Similar process shall be undertaken by the counsel appearing for the Union of India in WA 154 of 2025. That's right?
Yes.
Be notified. Now, when will you serve them?
My lord, we will serve them in, in the next 1 week, we'll serve them.
I will also serve them.
When Thursday? When is it Thursday?
Nane ಕೊಟ್ಬಿಡಿ.
I don't know, when do you want? 31st, you want to hear? But is it possible for your lordship, subject to your lordships, to have it on 31st for hearing, my lord? By then, all this will be completed.
31st?
Yes, sir.
July.
Wait on 31st.
If it is convenient for your lordship. Right.
That is fine. We'll see 31st.
In the meantime, my lord, we'll complete all this important step of
also
serving
may
everybody.
need to be-
Submissions, if any, be filed by the parties who are present before the court today.
Yes.
Before the next date of.
Yes, grateful,
Thank you.
grateful, grateful.
Great.
31st. 31st.
Is it 31st?
31st, grateful.
Yes.
Your Lordship, page number 62 of the writ appeal, which they have filed. The question here, it's mentioned, Your Lordship, that may I read, Your Lordship? Paragraph number 6. Yeah, with your lordship's permission, your lordship, page number 62 of the writ appeal.
Yes.
Paragraph number 6. 62, paragraph number 6, your lordship.
Urgency, ma'am.
Your lordship, we are the petitioners who filed this writ petition. The question involved here is under which statute an association can be formed. And it is very clearly mentioned. And in writ appeal, your lordship, writ. Where is the writ appeal? Writ appeal, extra. In writ appeal 564, decided by the division bench, your lordship, it is clearly mentioned that in a residential apartment, an association under the Karnataka Apartment Ownership Act has to be formed. And in the judgment also, it is very clearly mentioned, the question of law involved here is when a special enactment as KOA Act provides a particular mode for management or regulation. I'm reading page number 62, para 6, your lordship. Whether can be substituted by forming a society under the KCS Act. So question is whether Karnataka Apartment Ownership Act or the Cooperative Societies Act. Your lordship, there is a decision based on the writ appeal decision, which is very clearly pointed out that including the RERA, it is mentioned that an association under the Karnataka Apartment Ownership Act, because it is a specific statute and the specific statute will override the general statute. And now that has been challenged before this court. And one more thing, your lordship, there are 754 apartments and the sale deeds are executed for 751 also. So we are all the apartment owners, 3 of the apartments are retained by the builder. So there is a decision, recently there is a decision, in that also it was upheld. There is a difference which is created, allottees and the apartment owners. In case if the apartment owners are there or the sale deeds are executed, an association should be formed under the Karnataka Apartment Ownership Act. That is the decision. We have submitted all the case laws and the finding in this impugned judgment, your lordship, in page number 75. Based on the writ appeal, your lordship, paragraph number 18. The contention of learned counsel for the appellant that in view of the project being registered under the provisions of RERA in compliance of section 11(4)(e)(f)(g) of RERA, a cooperative society is to be formed. It is not acceptable. The said provisions of RERA would mandate the builder to enable formation of a...
Who is managing the society?
My lord, there is no mandate, your lordship.
My lord.
RERA says that section 11(4)(e) of RERA says that in case if in the absence of local law, it is very clearly mentioned, in the absence of local law, you can form a cooperative society or a society. Here we have a local law, which is the Karnataka Apartment Ownership Act, so it cannot be formed. So that is the section very clearly mentioned in RERA. So that section it is cited, and even after considering that, your lordship, the urgency in this
No, there
sense,
is
your
no
lordship,
urgency, my lord.
maintenance.
Let the council complete her submission.
She's misleading the
Yeah.
court.
1 minute, ma'am, we'll come back to you.
Your lordship, there is no misleading. Everything is based on the decision. Entire case is based.
Asking you, what
Yes.
is the urgency? You said there is an urgency.
Yes,
have
your
now
lordship.
protected you are appearing for respondent number 9?
No,
No, I'm appearing for respondent petitioners,
Oh, the original petition.
original petitioners, your
For
lordship.
respondent number 9.
I appear for the respondent number.
See, we have worked out a sort of a mechanism in the last order. And the respondent number 9 was basically stating that, you know, it is only respondent number 9 which is, you know, undertaking the services.
No, the difficulty here is this, my lords. We filed pursuant to your lordship's directions, we filed a memo of statement. Now, what has happened in this society is 754 apartments, out of which 500 apartment owners are paying the maintenance. We are collecting the maintenance on behalf of them. We are raising invoices. Some of the members and aides of the cooperative society, the appellant herein, they are instigating the owners not to pay the maintenance. I placed that on record as well.
See, that is true. In fact, we were told about this also.
And they themselves are not.
Then you are not providing any facilities to them.
We are indeed, we are 500.
Those who are not paying, you don't provide.
Yeah, we've stopped that maintenance.
Do it.
Your lordship, because of the.
They will come back.
My lord,
One,
Yes, now you tell us.
yes, my lord. Firstly, the writ petition was filed concealing the judgment of this Honorable High Court, the Chief Justice bench order, which has formed this cooperative society. It is ridiculous that the single bench has set aside without any, my lord,
The judge has set aside. In her
single bench of this Honorable High Court without any reasons has set aside this order, and the dispute is not regarding whether an association has to be formed or a cooperative society, which has already been decided, and a cooperative society has been legally registered by the Department of Cooperative Societies, my lord. And subsequent to that, in a contempt petition, this judgment of Chief Justice bench upholding the cooperative society as functional. According to that, the board has to function, but these petitioners who are illegal residents who have occupied the flats without OC, having enjoyed maintenance for years together, free maintenance for years together, when the builder was extorting money from us, heavy maintenance charges from us with GST in his business account, making wrongful gains, my lord. According to the law, he cannot collect maintenance in his account, my lords. He has cheated us, my lords, and even now he is harassing us without clearing our garbage. I have filed 2 contempt applications, my lord.
Because he has a view, he said you are not considered.
He need not control. We have a rare order which says he has to maintain free, my lord, and it has attained finality. And as per the RERA Act, he has to bear all the outgoings. No builder sits for 10 years, my lord. He is sitting here for 10 years harassing us. Your lordship, We have formed a society to take over. We are on the side of law. Association cannot be formed at this stage. It is contrary to the act.
Both of you being the residents are fighting. You keep fighting and nobody will come and clear the bargain.
We are not fighting, my lord. We are fighting.
That is what is happening here.
Oh, no, my lords.
Not only there.
They are in collusion with the builder.
Thanks. You
They are-
don't know about the community living.
No, my lords.
That's it.
My lords.
best example
we are-
in this country of community living society, my lord. If you
You
see the
don't
Maharashtra
know.
example, my lord.
You don't know about that.
We have formed, that's why we have formed the cooperative society.
My lord, this.
They
The
are,
fighting itself shows it.
no, we are
You
not
saying
fighting.
Cooperative society, it is not cooperative.
It is cooperative. My lords,
KOA is a illegal association. The statute does not mandate it.
my lords, they are
It is not
opposing
registered.
us.
Supreme Court-
Instead of opposing the builder who has not given them the OC.
What you are saying itself is showing that it is a non-cooperative society.
No, it's not a non-cooperative
No, my lord.
society. It is
Supreme
formed.
Court Supreme Court has,
Cooperate with him then.
they have to cooperate with us, my lord.
They are
We
not
the people.
cooperating. They are harassing us, my lords.
It's order already.
Sir, Supreme Court has
lordship,
said.
Not want to abide by it. or not,
Majority
left
of the owners are cooperating with
Lord,
them,
Supreme Court
and
has
their
said that it
majority
is
of their
unregistered and
members also have
non-consumer
resigned.
organization, My lord.
My lords,
Supreme Court, my lord.
My
Interim
lords.
order, there is an interim order.
Yes, my
If
lords.
you want to respect it.
yes,
do
my
it.
lords, we have respected
Otherwise,
it.
Leave it.
But the builder has not respected it. He is not clearing our garbage, my lord.
He is cutting our power, my lord.
He is not giving us facilities. We have proofs. I have produced a contempt application. Kindly go through that, my
And the
lords.
respondent advocate
And
is
we have said so.
Yes, my lords.
We have said so. If you have seen the last order, if you contribute, he would take it.
Yes.
But finally, everything would be decided. That's the reason we have asked him to file your statement, what expenditure, what is the contribution being made by each of the resident, what are the expenditure being incurred, you will file a statement. Finally, everything can be worked out. You're getting the point? That's the mechanism we have said so.
Yes,
So
sir.
that you will contribute, he will do it. But this dispute need to be gone into.
Yes.
Once we decide, everything will fall in place.
Yes, my lords.
Now it's up to you.
Contribution is voluntary in all, my
Voluntary, my
lord.
lord, as written.
Obviously,
Yeah.
That's the reason
Yes,
we are
ma'am.
not forcing you to contribute.
Yes.
Yes, ma'am.
But you want your garbage to be removed, facilities to be given, you will contribute.
Then we allow us to remove, my lord.
We will remove
We
it.
had employed our people.
Because the
They
Chief
did not
Justice-
allow. My lord, I'll show you the photograph where they
Very
were
well,
written.
very well. We leave
Be
it
on
at
your
that.
own.
Just 1 minute.
The Chief Justice bench,
We will remove, my lord.
my lord, then the Chief Justice bench judgment will lose, my lord.
From next day onwards, either he will argue or you will argue.
Yes, my lord.
We will not allow both of you to
Yes,
argue.
yes.
Your lordship,
Then the Chief Justice bench.
submission.
1 minute, ma'am.
Yes, my
Getting the
lord.
point? We'll give you a date, just re-notify.
Yes.
Give the date.
Maharaj, if I may permit, in normal recourse, I wouldn't make such submissions because all allegations are flying fast and thick. The counsels on record are the office bearers of this particular cooperative society. They refuse to pay the maintenance. Their dues is up to 1 lakh.
We say nothing, we have done something, we have passed an order on the last day.
You act on that.
That order may be extended, my lord. Interim order may be extended.
your lordship, the question of law involved is totally different in the writ petition.
Continue, we notify.
Interim order.
You
Yes, my
first-
lords.
You first,
Grateful, my lord.
Question of law, your lordship, KOA or cooperative society, now it has come to a stage where the maintenance issue, which they can raise it. in
My
the
lord, Supreme
civil
Court
court,
has
your lordship.
clearly stated when a deed of declaration is registered that it.
we hear you. Leisurely we will hear.
Thanks, oblige, my lord. There are plethora of Supreme Court judgments upholding the cooperative society when a deed of declaration has been registered.
If your lordship, please.
Madam, date.
8-9. 8-9.
Okay, we'll come back after lunch. Yes, Mr. Saxena.
Oh, my lord, my learned friend wishes to seek an adjournment by way of mentioning, my lord. in
Your
my
lordship,
ma-
a short date may be given, your lordship, for this case.
We are giving a convenient date, ma'am.
Yes, yeah.
Okay, short
Serial
date
number,
not possible.
serial number
Yes.
65, my lord. I appear for the first respondent, my lord.
Unfortunately, my lord, two things. One, I come from Delhi. I wish I had been informed earlier.
My
Be
apologies,
that
my
as it
lord.
may, be that as it may, my lord, my writ appeal has worked.
It was mentioned in the.
Please,
That's
on the
right,
morning
I
it was
think-
mentioned, my lord.
I came in by a later.
Not,
I-
not inform the council.
I informed, my lord.
Now,
I informed immediately.
No,
You
you inform on behalf of Mr. Gonzalez.
please, my lord.
You are paying for the respondent.
Number 1, my lord.
You.
I appear for the writ appellant, my lord. The writ appeal has become infructuous. It has worked itself out. I do not understand why they seek an adjournment to begin with. Yes, if your lordship may just have a moment, that's it. That's why I prepared a little. Yeah. हाँ तो दो दिया ना. Please pass on to my lord. My lord, 6/11/23, a charge sheet is issued. This is a private company. This is not state. He challenges it by way of writ petition. I'm not on whether it is maintainable, not maintainable. That's not what I'm going into. The writ, the single judge, he
Interim.
stays the inquiry and so on. I file a writ appeal. The writ appeal allows for the inquiry to go on. Inquiry is concluded. The writ petition also gave him the liberty to file before the Labour Court a matter under the Industrial Employment Standing Orders Act. That has been worked out. He has filed a separate writ petition challenging that order. The issue is now,
Now, my lord.
This order, which is under challenge of 18th September.
yes, ma'am.
The matter entering grantor is extended until consideration of the application by the Labour Court. If the petitioner appears as such application, Labour Court within 15 days receipt of the order and switches. Now, what is the, why he was relegated
when-
to the Labour Court?
Yes, my lord.
You are the serious objection, 13th. Labour Court considered.
So serial number 4 is the order.
After the matter went to Labour Court,
The Labour Court has held in my favor. It has dismissed his application.
this single judge order has been worked out.
The single judge order has been worked out. The writ appeal has been worked out. He has now challenged the Labour Court order by way of a separate writ petition. If your lordship.
Lordship, may kindly take a look at interim order dated 25/11/2024, my lord,
This court.
of this honorable
We'll
court,
come
my lord.
back after lunch.
Please, my
Very-
lord.
My lord, serial number 47, my lord. I appear for respondent number 7, my lord. Kindly grant 3 weeks time to file objection, my
Who
lord.
is the other side?
Petitioner is there.
The request of counsel for the respondent.
Or 7.
Your lordship,
Okay, fine.
your lordship on submission, your lordship, serial number 57, your lordship. Your lordship, serial number 57, kindly 2 weeks, your lordship time, your lordship.
Who is the other side?
Your lordship, I am per the complainant in this matter, your lordship.
You should have the other side here.
Your lordship, sir.
Court officer. Court officer. Court officer. Hello. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 57 ಏನ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ರು ಮೇಡಮ್?
57 ಇದೆ ಸರ್, ನೀವು ಆಪೋಸಿಟ್ ಹೇಳ್ಬೇಕು ಅಂತ. ಇದೆ.
ಹೌದಾ, ಸರಿ ಸರಿ. ಅದು ಅಪೋಸಿಟ್ ಸೈಡ್ ಅಕ್ಯೂಸ್ಡ್ ಗೌರ್ಮೆಂಟ್ ಇದಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ. ಹಲೋ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಅಡ್ಜರ್ನ್ ಆಗಿಲ್ಲ, ಇದೆ ಸರ್.
Yes.
My lord, that matter.
Where is
Your
your
Lord-
pen?
Your Lordship. Lordship, serial number 57, Your Lordship.
Yes. Who is
Your
there?
Lordship.
Who is the other
And
side?
other side is government, Your Lordship. Yes.
It's a contempt matter, my lord.
At the request of counsel for the petitioner adjourned. Yes, tell us.
Please.
Friend is appearing. My friend is appearing online, my lord. See, 65 may be permitted to appear.
Now tell us what remains in this. Where is he? Who is your friend?
He's appearing.
Yes.
Lords, if I may.
Yes. Just give the file.
So, Lords,
Tell us what survives in the appeal.
There seems to be a problem with the connection.
This is 65.
May I attempt to help, my lord? Because he's.
Yeah, go ahead.
If your lordship takes the order, my lord, the order of this court, the writ appeal, my lord, that is
very
dated.
sorry, my lord.
My lord, he's back.
Yes, join.
If I
Yes.
may submit.
Yes.
Yes. So, Lords, I and my learned friend both agrees on one point that this writ appeal has become infructuous. However, my lords, the bone of contention is the order dated 25/11/2024, passed by this honorable court. Lords, may see my submission if my learned friend present before the court may hand over the submission.
Lordship may kindly permit me to submissions, my lord. That is
What submissions?
Lords, the annexure I would be relying on.
Annexures, that is.
Now come to this order first.
Yes, my lords. Lords, order dated 25/11/2024.
You are reading which paragraph?
Yes, my lords. Lords, I'm reading para number 7.
Yeah, read it.
By way of interim relief, it is directed that the inquiry against the delinquent shall go on. However, any decision at the conclusion of the inquiry shall not be implemented against him without the permission of this court.
That's
Now,
right.
Lords, it is clarified that the pendency of this appeal shall not be a ground for any parties to not proceed before the proceeding before the labor court. Now, Lords, after passing of this order, two developments happened. First, the inquiry proceeding got completed without the assistance of the defense representative. And second, the labor court passed an award declining my request to be represented by the defense representative. Now, Lords, that labor court award I have challenged before the single bench of this honorable court, and the single bench stayed that award. Now, Lords, the whole inquiry proceeding as well as the proceeding of the labor court is pending before the learned single bench. Now, Lords, my point is that if I succeed before the learned single bench, now, Lords, the whole inquiry proceeding will be vitiated. This is my respectful submission. Now, my lords, what they are asking is, they may be asking is that this writ appeal has become infructuous. They may be willing to ask for the permission. Now, my lords, permission cannot be granted because the learned single judge is seized of the matter. Therefore,
No,
my
no,
lords,
one thing.
yes.
You have challenged the challenge in this appeal is to an order of the learned single judge. Very right?
Now, my lords, before the single bench.
No, we are concerned with this appeal.
Yes, my lords.
What
yes,
is what is the scope of this appeal?
my lords, only with respect to the
Or the order already passed by the learned single judge? Now, after
Only one
this,
aspect.
what is the action you have taken?
Yes.
Just 1 minute. What is the action taken?
The writ petition number 14445 of 24. The final order of that writ petition is the subject matter of this writ appeal. What was the final order? The final order was you will not proceed on the charge sheet In the meantime, he has been given permission to move the Labour Court for matter under Standing Orders Act. This was the final order passed. I file a writ appeal against that order. That is the scope of this writ appeal.
Lords,
What does
one-
this honorable bench do? What it says is, you go ahead, that is that stay that had operated on the charge sheet. The division bench said, carry on with the inquiry, go ahead with the inquiry, allow him to go ahead with that matter before the Labour Court. In case you're passing any final order, please take our permission and do whatever you need to do as the inquiry concludes.
What is the action taken?
No action has been taken. In the meantime, that matter which he had been permitted to file before the Labour Court, that he has now challenged by way of a separate writ petition, not this writ petition.
What did the Labour Court do?
It has dismissed his application under the Standing Orders Act, saying that in these proceedings, your prayer that you want a designated person, Mr. A, to represent you as your departmental inquiry
That
officer,
has been dismissed.
that has been dismissed. And that he has already challenged by way of a separate writ petition. In that writ petition, the learned single judge has passed an order staying the operation of the Labour Court's award. Now, my submission is, my lord, as far as this writ appeal is concerned, which arises out of a previous disposed of writ petition, nothing survives.
Lords, one clarification only.
So this remand has been only to the extent that not even a remand, you will go to the Labour Court and work out your remedies under
Quite
the
right.
industrial standing orders.
Quite right. So he does that.
He does that.
He fails there.
See, nothing on the inquiry here.
Nothing.
But the conclusion, the outcome of that industrial standing order before the Labour Court may have a bearing on the inquiry.
Which has
Because
now
he'll
been
get
stayed. Which has now been stayed by the learned single judge on his behest.
Yes, I think nothing survives, but you are the appellant.
Of the
Lords-
previous disposed of writ petition. Now, nothing that survives in that writ
Who
petition.
is the appellant here?
I am the appellant here.
So you withdraw it.
Very well, my lord, I'll withdraw it as infractual.
Lords, only one,
That's all I
only
was
one.
saying.
Lords, only one
He is
submission.
withdrawing
I am
it.
the
He is the
dominus
appellant.
litis. I am the dominus litis in any
That's
case.
right.
Only, Lords, one submission. First of all, the order under challenge before this honorable court, he has challenged only limited aspect of the impugn order, that is with respect to the continuation of the inquiry. As far as the issue of defense representative has been concerned, it has not been challenged before this honorable court. Now, Lords, that issue is coming before the single bench.
Inquiry has been held?
Yes, it has been held.
Inquiry has been held?
Yes.
No.
It has been held.
Lords,
happened in
inquiry,
It's been concluded. The copy of the inquiry report was sent to him. His comments have been received. So,
Without the
and that
assistance
he has
of the-
challenged before the learned single judge anyway.
What?
The condition precedent of the inquiry where he says,
That's right. But even the inquiry proceedings have been challenged.
no, my lord, that he'll have to challenge before the Labour Court under the industrial dispute.
Then how would you answer what his submission is by way of an entry? It is directly inquiry against the delinquent may go on. However, any decision on the conclusion of it shall not be implemented against him without the permission of this court.
Quite right, my lord. If he seeks any such injunction, now that he is before a learned single judge who seized of the matter as a condition precedent to the inquiry.
But no, what we are putting it to is this. Suppose there is a conclusion on the inquiry by you,
Please,
can you go ahead with that conclusion or with that penalty or whatever
Please.
without the permission of this court?
my lord, the Labour Court's award has been stayed. How can I?
no,
At
Lords,
his behest in another writ petition, he has got it
Lords,
stayed.
they record the submission and dispose of the writ
That's
appeal.
only on the aspect of industrial standing orders.
Which is a condition precedent to the whole inquiry.
Then you take a call whether you want to withdraw it.
In that case, my lord will allow me to advance arguments as my learned friend is here. Can I advance arguments, my lord?
Not today, then we will have it some other day. We have a limited sitting post lunch.
Yes, my Lords.
Oh, I see. I see.
We will have, just list this, see, then he may be right. He says 7 is the precedent. So today, even if you have went ahead with the inquiry, you can't take any final decision without the permission of the court. But if you withdraw it, that means
If I withdraw it, that interim order goes, which is what he's affected by.
we don't.
Now, my Lords,
Please,
my Lords,
if
only,
I withdraw this writ
Be
petition, my
notified.
lord, the
Be
interim order
notified.
goes. That
will
is what
hear
he's
it.
opposing.
Ah, that's right.
That is what he's opposing. He's opposing my withdrawal of the writ petition for the reason that if I as dominus litis is to be, I am to withdraw this, then all orders go.
Now, my lords, if I
Then
succeed
by
before the
withdrawing
learned
it
single
is become, in fact, you know, you take a call, you want to have, we'll have it some other day.
Very well, your lordship may have it some other day. I'll satisfy your lordship on how this has been worked out.
Yes.
Just give it. Just re-notify, just give the date to the court officer,
Could it be 31st of this month, my lord?
31st.
Very
Okay, 31st July.
Please.
Much
So
obliged.
next. Dreadful.
Fifty-one.
I appear for the petitioner, my lord, in this matter. On the last occasion, your lordships were pleased to direct the Commissioner Excise to file an affidavit regarding the distance between the temple and the bar, my lord. That is to.
For some time, for the reason, my lord, that the documents are in Kannada. My lord could grant me a week's time, my lord, I'll file my objection.
What are your broad instructions?
My lord, my first contention, which I'll take before my lord is, my lord, the order of shifting that has been passed, my lord, now the CL9 licensee, my lord, has shifted his license to the place where the petitioners are aggrieved about. My lord, that order has not been challenged, and that order has been passed by the Deputy Commissioner of Excise. My lord, that is my first submission. And that order has also not been produced before my lord. Then the second contention is, they are seeking for cancellation of a CL9 license, which is very serious. And that cancellation takes place only if there are violations of the my lord, license conditions. My lord, now according to us, the distance that has, and this my lord, the license premises is in the second floor of a building. It is not in the ground floor or anywhere else. My lord, as per the my lord, the rules, Karnataka Excise General Condition rules, my lord, the measurement has to be taken from the middle of my lord, the institution to the middle of the license premises. My lord, which according to us is 106 meters.
How much is the requirement?
My lord, it should be 100 meters.
My lord,
So you say
I'll-
beyond.
Beyond.
I'll pass on the rules, my lord, for a minute.
Just 1 minute. When will you file it? Should be filed earliest. When will you file your status report or reply affidavit?
My lord, may grant me a week's time.
Week's time.
My lord, sir, I undertake to appear for respondent number 10.
You are the,
License.
you are the licensee, yes.
My lords, I
I
undertake.
require 2 weeks, my lord.
You will file it in 1 week. The state is filing, you also file it.
For respondent number 3, my lords, I undertake to file wakalat in the coming 2 days.
You have to file any response,
Yes, my lords, will.
file it in 1 week.
Okay.
The respondents to file their,
My lord, another submission is, my lord, the license premises has already been shifted and now it is, my lord, they are running the CL bar and license.
where have they been shifted?
Where, my lord, they are aggrieved. We are functioning there from last 4 months, 4 to 5, 6 months, almost 6 months.
No. You say they have been shifted.
Yes,
Yes,
my lord.
yes.
That is what is submission.
No, this is the same place of which he is agreed of.
Yes, yes.
Very right. So that's his grievance.
Yes.
You are operating from this. I have a grievance. It is within 100 days. That's what he said. We file 1, 2. Who is BBMC?
My lords, respondent number 3.
And whatever sewerage board?
No.
Who appears for sewerage board? Police department, you appear, ma'am. 6 also you appear. 7 also you appear. 8 is Government of India. And 9 is labor you can. You are the respondent number 10. Just say that respondents 1, 2, 3, 5, 6, 7, and 9 shall, and also respondent number 3 and 10.
I may not be taking, my lord.
It's all right, man, doesn't make any difference. You have to come through, the excise department need to file it. And 3 and 10 shall also file their reply affidavit within 10 days, just 10 days. Re-notify all. No, rejoinder be filed within 1 week thereafter.
Please,
Must file a response to those. What is your stand?
please, they have to serve a copy on me, my lord.
Oh, they will, obviously.
please.
When they file it, they will
We will,
serve.
we will,
Filing will serve the.
Yeah, yeah.
much obliged.
6/8. 32. Serial number 32.
Your Lordships will do the needful during the course of the day. We had to pay process for the respondent number
Notice
4
be
and 5.
issued to R4 and 5.
Please.
22/9. 33. Serial number 33.
I appear for the petitioner. For respondent number 4 to 7. This pertains to a totally illegal construction.
For
in the-
R18.
Wait, let me say. A totally illegal construction in the regulated area of a centrally protected monument. The fact that this illegal construction is admitted by ASI, they have clearly stated no permission has been obtained from us. Regulated area construction requires permission. They clearly say no permission has been granted. Admittedly, there is no license and building plan approval from the Nagmangala town panchayat. So this went on for a long time, my lord. And during the course of several hearings, on 26/2/2020, your lordship may kindly peruse the order sheet. The eighth respondent undertook to demolish the illegal structure. It is recorded. Then further, they are also on the subsequent days also they agreed. Then orally it is not recorded. They continue to agree to demolish. But now all of a sudden they have changed their stance and told they will demolish only 5 feet, not as per the standards of the ASI. And ASI's objections, your lordship may kindly say, I will read. It is very categorical. The objections of ASI.
Who has to implement this ASI stand?
Yaru bandilla.
For the ASI, my lords, the respondent number 8 has sent a proposal to us to reduce the building height to 5 meters, my lords. 5 feet, my lords, and we have placed that before the ASI. My lords, I see for 2 weeks, my lords, the decision will be taken by the ASI.
What?
Regarding
This-
that proposal.
You are operating for whom?
ASI.
No, ASI, he says ASI has taken a categorical stand.
Yes, my lord. I'll just, your lordship permits me
So
just.
they have to send proposal to what? For what proposal?
The eighth respondent, that is the person who, the institution which is constructing the illegal building, Jamia Masjid, they have undertaken to demolish the entire thing and now they're telling we'll reduce it by 5 feet.
Okay. Ma'am, you appear for whom?
Respondent number 8, your lordship.
What is your stand, ma'am?
This issue pertains to a mosque, your lordship. This is not a new construction. This is a gazette notified Waqf property which has been in place for over 140 years. Now the issue pertains to whether the mosque that has been, renovations have been going on, whether this falls under the ambit of the regulated area, which is 200 meters. And also, your lordships, we have at the previous occasion.
200 meters from where?
200 meters from the protected monument, that is the Saumakeshwara temple, that is a protected monument under ASI. Anything that is newly constructed in and around that 200 meters, it is a rule that you obtain an NOC and no new construction must be come up. And pertaining to the renovations, your lordships, this stance was not clear. The respondent number 8 has also sought for ex post facto permission. While also saying, or while also mentioning my learned friend has also mentioned that we have undertaken to demolish, but that is not the case, your lordships. At the behest of this honorable court has suggested us, we had also suggested that though we are not in the premises of the 200 meters, this is also by way of the RTA report, your lordships. We have sought an RTA report, what is the distance from this protected monument to the Jamia Masjid. It says 200 meters, your lordships. That means I fall out of the ambit of the same. But they brought up the aspect of architectural sanctity. So vice versa, your lordships, we do not intend to have any communal disputes in and around that area. That is why we had proposed, that is the heights of the minaret we will reduce. The building, the whole construction in itself is not the height of not above this thing, your lordships. It is only the minaret, that is the minaret which is used to pronounce announcements and make azan, your lordships. Only the minaret. This is the architectural structure of the mosque, your lordships. And pursuant to that, ASI made submissions telling there have been instances where in Karkala where an ex post facto permission was granted, but provided the said submissions of the respondent number 8 are given by way of an affidavit, and hence we will consider the same. Pursuant to that, we have gone ahead and filed an affidavit stating that we are willing to reduce the height of the minaret. Though we are not under the ambit of the regulated area, we are willing to reduce the height. Moreover, your lordships, a survey was undertaken, and in and around 200 meters in that area around surroundings, there are 1,650 houses, municipality building. There are schools, there are police stations there. The municipality in itself, the respondent number 2, they themselves have a building over there. This is a detailed survey report that has been provided, put forth by the ASI, your lordships, from respondent number 4 to 7. If this is only, if this is the aspect that any new construction must be struck down, all the 1,650 houses will also fall under the same thing, your lordships. Now this only pertains to the reduction in the size of the minaret that we have proposed.
What do you say that this, the mosque being or the place being within 200 meters or so?
It is not under 200
It is not
meters,
there
your
in the
lordships.
objection. Now she is orally submitting. In their objection, they have never taken up the contention that it does not fall in the
What
regulated
does
area.
archaeological survey say?
Your lordship kindly permit me to read it. I'll just read a few paragraphs, my lord. From page, your lordship may kindly go to page 244. Page 244, my lord. Objections of the Archaeological Survey of India. I'll read it out, my lord. Paragraph from 5, I'll read it out, my lord. The Conservation Assistant ASI Sri Patna issued a notice dated so and so as per Annex D to the Secretary of Jamia Masjid, stating that he has taken up illegal construction in the regulated area of the ancient monument. Page number 243, my lord. May I continue, my lord?
Yes.
Namely Sri Saumakeshwar temple within 120 meters, and as such advised him to obtain NOC from the competent authority for such construction. Such said notice copy was also sent to the Tahsildar Nagamangla Chief Officer TMC Nagamangla. In spite of issue of such notice dated so and so, the 8th respondent continued with the illegal construction, and as such the Conservation Assistant again issued a notice dated so and so to stop the illegal construction forthwith, and again advised him to seek permission from the competent authority. Conservation Assistant was good enough to send the prescribed form to enable the Secretary of the 8th respondent to submit the forms to obtain permission and stop construction till obtaining permission. In spite of the orders of the ASI, the Secretary of the 8th respondent did not stop the illegal construction. The second petitioner submitted an application under RTA Act dated so and so to the town panchayat seeking various information about the illegal constructions in question. In response to such application under RTA Act, the public information of the town panchayat furnished information which is as per annexure so and so. It is clear from the said information that no license has been issued for such construction by the town panchayat. In addition to the one such application, one NK Govindraju under RTA Act seeking information, town panchayat furnished information as per annexure H, stating no license is issued for construction of any building within the prohibited area of the ancient monument. Then, your lordship, I'll skip the next paragraph 7.1, my lord. The Atta part CPI office in the regional director also informs Sri D. Madhusudan Adiga, advocate information dated so and so.
43, no?
243, my lord. The running page has been given by the office.
That's right. Even we have at 243, but we don't have 7.1. This is the affidavit filed by respondent number 8.
No, my lord. Objections of the ASI. Objections of ASI. Running page was given by the office. Objections of
247, your lordships.
7.1, what does it say?
7.1. And that apart CPIO office of the regional director also informed the Madhusudan Adiga advocate information dated so and so in response to his application dated so and so in respect of the construction of the building by the Jamia Masjid. The said communication is as per annexure L, which clearly disclose that Conservation Assistant has issued 8th respondent that 8th respondent has not obtained any permission from the competent authority, and in fact a show cause notice dated so and so bearing number so and so was issued by the SA ASI Bangalore to stop the unauthorized construction. Then your lordship kindly go to para 11, my lord. Very, very important from para 11. Para 11, it's very important, my lord. In order to submit a report to the competent authority as per the request letter mentioned above, an inspection was made on 2/11/2017. The Deputy SA Bangalore Circle submitted the inspection report on 7/11/2017. Thereafter, SA submitted a report to the RD competent authority void letter dated so and so. Copy of the inspection report submitted to the RD is produced as Annexure 7. The report discloses that the construction put up by Jamia Masjid is a new construction. Repeatedly, she says renovation. It is not renovation, my lord. They are misleading. It is a new construction. Photographs also I will show it to your lordship. It is a new construction, totally a new construction, not at all a renovation, and not a repair renovation as claimed by them. The distance of the construction within the regulated area, as mentioned in column number 8 in the report, which is 133 meters from the protected monument. The height of the building is 42.47 meters with G+2 mold work and 2 minars. The location of the construction is on the southeast side of the monument. The photographs of the construction and view of the temple from part of the report. The height of the protected Gopuram is only 25 meters, whereas the height of the minerals are at the height of 42.47 meters, and such construction has totally marked the architectural importance of the monument. It is nearly 17.4 meters than the permitted limit, my lord. In other words, almost 42 feet, it is more than the permitted limit. 42. The next parameter. From the narration of these facts, it is clear that the 8th respondent has violated the provisions of the Act by putting up unauthorized construction within the regulated area of the ancient monument, which is punishable under so and so of the Act. The offences committed are deliberate, and the offence is committed in spite of clear instruction to stop the construction till permission is obtained, and also advising them to obtain permission for which requisite forms were enclosed. The 8th respondent did not bother to comply with the mandatory provisions of the Act. Unfortunately, ASI is not having men and machinery to stop.
Now,
Further, one minute, my lord. We have
seen the last order. Let's see this order also. Now, you are for the central government?
Yes, appeal for the ASI.
Now, who has to take action?
We are supposed to inform the state authority, and state authority has to demolish that particular construction.
Now, but this order of 21/3/24 is in a way conclusive. Appearing by having turned the pages on record, we find a lot of force in the submission. We have the considered view. Deputy Commissioner should accomplish the task as indicated above. He shall ensure all necessary records are secured from the concerned quarter forthwith and transmitted to the office of respondent number 4 for further process in the matter. The task shall be agreed. Now, have you informed them?
My lord, we have informed them about this, as well as what happened, my lord, during the pendency of this particular PIL. The submission was made by the others, saying that there are various other construction which are also within the regulated as well as the other areas, which is within the area of the
within 100 meters.
Then, my lord, this honorable court directed us to conduct a survey.
Regulated means some conditions. So this is within 100 or outside beyond?
Outside 100.
Oh, it's a regulated area.
Yes, sir. Within 200, but above 100.
Then regulated area.
Yes, sir. Even if it is a regulated area, they are supposed to take the permission, and then only they are supposed to put up the construction.
What about the regulations? What is the height, everything?
That is there in the same paragraph.
The height of the minar would impair the aesthetic value of this particular building. Sorry, this particular monument.
That is what was noted, and
Yes.
then the Deputy Commissioner was tasked with accomplishing that.
No, my lord, that is not the task, my lord. What happened, my lord? We were supposed to identify the other construction which have come up within the regulated area, and we could not do it. The reason is that, my lord, there was a law and order problem. Then this honorable court directed the Deputy Commissioner, state authority, as well as the SP to provide the protection. Under their protection, we carried out the work. And
you carried out the work?
Yes, sir. And then we submitted the report also this honor.
What does your report say?
There are various other construction, my lord, which are within the regulated area, my lord. But those construction, what is the impact on the monument also, we are in the process of understanding. But this particular building, my lord, the height which impairs the monument.
No, that report has been shared with the state.
Yes, sir. The copy has been provided to them.
On that, they have to take action.
Yes, sir. Yes, sir.
Not to differ quite this the entire intentions, not
See, you have to implement that order. You cannot truncate his order. Is there any provision for that? No, can you differ with the report which he has given? Let us say he has, ASI has given some report. Now, can you tamper with that? Or you can say that, no, 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 I will replace my opinion into that. That you cannot do. No, that may not be one, that may be one of them. There will be many others. Is that only one?
The minaret is the main issue.
Yeah.
And that has been escalated in this particular PI. Then, my lord, the other parties started saying that there are many other construction, government agency of.
That's right. And there are many other construction within this 100 meter, 100
Yes,
to 200,
as well as the
which are also beyond your permissible.
Yes, my lord. Without obtaining our permission, the construction has been put up.
So what are you doing there?
My lord, for that, my lord, we have initiated the proceedings. We have issued the notice. They are supposed to submit their reply. Some of the cases we have received the reply, and some of the cases we are passing the orders on.
Okay, very well. Now what is now you have given to the state government?
Yes, my lord. We have
For them to take action?
Yes.
Your lordships may kindly permit me
No,
to take.
Now, the issue is with respect of this minaret, my lord, the height of the minaret. That particular height of the minaret is affecting the aesthetic
But
value of the
you will convey to the state government, no?
Yes.
They will for them to take action.
Yes.
Do your job.
Yes.
Then we will see.
You take a call on that.
Take a call.
You have to take. We are not. You have to take a call.
Ma'am, we are not understanding. Whosoever will take a call, it has to be come within the regulation. Either you take or they themselves take. Simple. You're getting the point. That's for you to do it. If they say very well, they say that they will do it themselves. Well, okay, do it and inform you. Then you will inform them. Archaeological survey, look here, it has been done. So,
Lordships may kindly permit me to take.
I don't think this is that way. It's basically the archaeological survey. They will convey to the state. Maybe you have expressed to the state that you will reduce the
Yes,
minaret.
your lordships. Only I want to bring it to your lordships' notice that this court has only directed. This court had considered the fact that all the annexures marked ranging from page number 176 of the petition, your lordships, these are RTA applications that have been made. So the Nagmangla town municipal corporation that has also not obtained an NOC to construct
You're
the
right,
same.
ma'am. We are with
That
you
is
on
why, your
that.
lordships.
He is saying so. He has called for the notices, reply is being then take action. We will ask him. The status report for that we file. The point.
Lordship, kindly.
What do you say?
I will. Order dated 26.
That's true.
Well, order dated 26/2/2020. The learned senior counsel appearing for the 8th respondent states that the 8th respondent has submitted a proposal to the 9th respondent, that is to the Waqf board, not to the state, Jamia Masjid to Waqf board, for removal of the illegally constructed part of the structures. The learned counsel appearing for the rights respondent seeks time to take instructions and to make a statement within a period of 1 week from today. That is from 2020. Till this date, they have not made it. Then further, para 9. To enable the 9th respondent to produce the decision taken on the proposal of the 8th respondent, the petition will be listed and so and so. And on that day, an affidavit shall be filed. Till this day, it's not filed. That is one thing, my lord.
Just 1 minute. Mr. Deshpande, when are you informing them? What have to inform the state government? The action to be taken?
Yes.
Let's see the prayer. In the course of hearing, something is being pointed out between 100 and 200, and archaeological survey, who has to look into all these aspects, is also saying that between 100 and 200 being regulated, it is their plea of respondent number 8. There are other things, other structures which have come between 100 and 200, which are also beyond permissible limits, or NOC has not been taken. Will not the action be taken? Tell us.
The action can be taken, but with regard to this reputation, we can dispose it off because keep it pending because the respondent number 8 has come
Ma'am, the state will go what the archaeological survey is doing.
Letter in letter and spirit, what archaeological survey has stated has to be implemented by you. Are you abiding by that? And then see whether eighth respondent makes a request or not, that is unconcerned for you. You have to take a call on that.
Ma'am, we will tell you. Respondent number 8 saying why I have been chosen, why I have been singled out. Are you saying?
Yes, Your Lordship, because
That's
we
it.
have filed an ex post facto
saying so.
this thing.
Why we are being singled out when there are others also? She's right in saying so. And now this is the prayer, what is being sent by the archaeological. We are looking into it because that's the allegation made. And this allegation directly against the archaeological survey. The NOC is required from you?
Yes. Your Lordships, please, one more submission, Your Lordships. The archaeological
Take out
survey had made us.
all constructions which do not have the NOC in 100 to 200 meters, go ahead with them. That is what the earlier order stated. That is why the DC was also here.
The ASI has categorically stated that the state government is not helping.
And even then,
They are categorically stated in their, I'll complete that reading, my lord.
Your Lordships,
One paragraph, I'll read it, my lord. Only one.
All right, please just.
ASI had made an exception, Your Lordships, that brought up an incident in Karkala where they had granted ex post facto permission, Your Lordships, keeping in consideration the situation that is arising and the tension, and for the well-being of all and the greater interest of Your Lordships, it was suggested that we file an affidavit and also fresh representation.
What do you want to
Same
say?
has been done.
Please tell us. No, you have something to say, please convey, tell us.
DC was here, SP was here. That was maybe of one, but what is recorded is he has to implement what the report has been given.
Your
The
lordship,
learned AG is here, we'll ask him also what is the state doing.
well, lordship,
Maybe in other case, you are there, obviously.
As your lordship said, my
Lord-
lord, law is uniform to everyone, my lord.
lordship, kindly see para
Irrespective of who is there before the court.
Has summed up in one liner. That's what archaeological survey is doing.
My lordship, para 13, the deputy
Okay,
commissioner.
please, just 1 minute.
Only 1 minute. The deputy commissioner, though one of the authorities under the central
All
act
right,
of
please,
flood-
we don't
No,
understand what is this. We have conveyed to them.
he does not act. That's what they say, my lord.
We'll say, we will see it, what the archaeological survey is conveying, because they are yet to convey.
Yes, ma'am.
Then we will see it what the state government is doing. We have conveyed to the learned AG also.
No problem.
Just say this.
Your Lordships may kindly fix a date because it's a 2016
We'll fix
matter.
up.
all
Fixing it
cases
in.
we are fixing up.
Yes, yes.
And we'll fix up all those who are not doing.
Yes, Mr. Deshpande appearing for the archaeological survey. Yes.
We have communicated to the deputy commissioner as well as the superintendent of police in the year 2016 itself to act that.
Let them come, give once again.
Once
my
again,
lord.
we will give the.
Let him give it, we'll follow it up.
But this must be followed by other communications also.
Yes, once again, we will communicate.
DC was called here once.
I think we should call the,
We look into it right away.
by DC, we should call the
And
the head.
thereafter, further report is not at all there.
Once
We
again,
look
will
into it, my lord, and we'll see necessary.
Sir Shetty, it's 2016.
16, 9
And
years
There are
back.
orders.
There are orders.
2020 also, there's an order, what your lordship, what is pointed out.
See, on 18/11/23, Deputy Commissioner as well as SP were here. This order speaks of that. But thereafter, no action has been taken.
So may have given reasonable period, my lord, to report what has happened.
No report has been submitted.
So that's what, my lord, just any reasonable period, your lordship may.
Just say that Mr. Deshpande appearing for the Archaeological Survey of India state that despite many communications sent by the Archaeological Survey to the Deputy Commissioner of which zone?
Mandya district.
Mandya district. No action has been taken by the state government.
Well, that was in 2016.
But no, 1 minute. So 2016 is beyond limitation, ma'am?
No, my lord,
Then-
it's not that. My lord, we will do it, my lord, we will do it, but let us be clear with the dates, my lord.
We will, so on, what is the date, Mr. Deshpande?
8/1/2016.
So that's what we have said. 8/1/2016. Have you sent thereafter also?
Yes, my lord. Subsequently, my lord, we have.
When, which years?
29th August 2017.
Even thereafter, communication was sent on
subsequent communication readily.
No, this 2017,
Yes, my lord. 29th August 2017.
29th August 2017. We also note that orders have been passed by this court on 18/11/23.
Sorry, my lord. Sorry, my lord. The communication is dated 8/1/2016, my lord. That is one communication. The follow-up communications are available, my lord, which I will
Just give the dates on those.
Yes.
8/11/23, 18,
8/1/2016.
yes, sir. Your statement is also there, Learned Advocate. Mr. Shetty, this is order dated 18/11/23. Huh?
11/23.
Was it after you have taken the position?
I think
After subsequent. It's my,
troubling now,
that's what.
maybe.
Then 21/3/24 and 21/3/24. To stop, Mr. Deshpande says that all the communications which have been sent to the Deputy Commissioner shall be once again sent to the Deputy Commissioner.
Just coordinate with my learned friend.
Deputy Commissioner to enable the state government, Deputy Commissioner take further action. So the same be sent within period of
15 days.
15 days. Full stop. Mr. Deshpande further states that insofar as those constructions now,
Yes, sir.
which have come within the regulated area between 100 meters to 200 meters, notices have been issued and replies have been sought for. Further action have to be taken on those replies. That's right. He shall file a status report on the action taken on the show cause notices. On the show cause notices before the next date of hearing. Within 4 weeks from today. Okay, re-notify all.
In respect of this particular building, my lord.
It's on everything.
This communication is being sent for them to take action. What is further action? That he will file a status report. The status report shall be filed by the state government on what action has been taken on the communications received from the Archaeological Survey of India,
Please.
at least 1 week before the next date of hearing.
We'll do that, my lord. We'll place it before you.
My lord, can I have a
Date.
delivery of this order?
After 2 days, we'll upload it. You want hand delivery, the order?
Yes,
my
my
lord.
lord.
Okay.
Immediately I send messages, emails. my lord.
Okay, we'll give it. Ma'am, just give the date.
22nd August.
Next. See, there is, we have to get up from this.
3:30.
Which is this? Which is your matter, Mr. Nandakumar?
Advertisement matter, my lord.
What is that? Just share.
Advertisement matter. Last occasion.
I appear not for the respondent. But this matter relates to the advertisement rules, my lord.
Okay.
The lordships
Mr.
had heard
Nandakumar,
it
you
last
were to-
occasion.
You were to come back.
No, my lord, last occasion, what I submitted was, Mr. Naganand's suggestion was that the bylaws be, my lord, they be permitted to release the bylaws. That, my lord, would put everything.
The bylaws need to be implemented.
Well, please,
Yes,
notified.
Problem is that, your lordship, the implementing application filed a document, Supreme Court, they went to Supreme Court BBMP, page number 311, your lordship, in the IA for implementing.
Supreme Court?
My lord,
The Supreme Court has said to hear the main matter itself. Honorable
also
Supreme
it
Court.
was mentioned by the senior counsel, my lord.
Kindly see.
There is no order passed again. because
No, it is there,
that
kindly
day-
see, your lordship. In the implementing application.
My lord, may I explain, my lord, what has happened, my lord?
Yes,
May
We'll
I
have
explain
it
what has
tomorrow.
happened?
We have to just get up. We'll have it tomorrow.
Tomorrow, your lordship.
Tomorrow, Mr. Naganand.
My lord, everybody is saying this can be closed, my lord.
Yeah,
Even the
it can be
petitioners
closed.
say-
What do you say?
Lordship, the order is there, I don't know, I can't.
The Supreme Court order, my lord. The
My lord,
petitioner is getting the
really,
relief he
go through
wants,
the
he
order,
still
my lord.
resists. I don't
Want to
understand.
see, we don't want to,
No, may I
not
read?
to see the order.
I bowed
of
out,
Supreme
of course,
Court.
of
Matter
course.
itself can be
course,
disposed
of
of.
course.
That's
Fine,
what the Honorable
of
Supreme Court
course.
said.
My learned brother has a bench.
Of
We
course.
have to get up there. We'll have it tomorrow.
Tomorrow.
Tomorrow,
Great.
your lordship,
Tomorrow.
we'll make.
Serial number 30.
Morning at 2, afternoon 2:30.
Mr. Nandakumar and
Your
Mr.
lordship.
Yoga, mention in the morning tomorrow.
Can I,
and take it
can I
up.
make,
Supreme Court order.
My
with my
lord,
learned
can I make a request?
Number
The
36
same matter,
also.
Can I make a request?
The
madam?
court officer will give the date.
Iri, madam, mention.
Same
How does-
matter, which my lord
You just give it to the court master so that we can have a look.
Can I make a
Tomorrow
request?
morning,
Serial number 35 also tomorrow, my lord.
We will see what is the urgency.
My lord, the BMRCL Bangalore Metro, my lord, they sought permission to
Tree cutting.
seek is covered by judgment.
We'll have it tomorrow.
Your lordships, my lord, serial number 64. I'm a pensioner waiting for my, you are,
We'll give you a short.
this court, chart date and kindly fix a fixed time, my lord. I have been before you since.
We'll give you a short date. Whenever the matter is listed, please mention it. Yeah, just that also give a short. Please don't clog the board. Don't clog the board. It's very difficult. Wherever we know which is the urgency, he had mentioned earlier occasion also, he had also. That's the reason we are giving a short date.
My lord, this court was kind enough to give me 4 times date, but it could not reach. Therefore, I would pray for a specific time, my lord.